Yes, my lord.
Yes. Please. Application order for need not mention, please. Let us take this, Mr. Rokit, then we'll take on the other matters. Order for an application need not mention. Other matters, please wait. We'll just take up these matters.
Order 41.
Yes.
May I mention this is Logio matter?
Logimo?
Yes. And division bench order pass this order to the my lord.
Yes, yes, we understand. Yes.
My lord, I'm mentioning one first appeal of 2023.
Hearing, sir, we are not taking up.
My lord, it was mentioned twice before your lordship.
Maybe thrice, 4 times, but we are not including any matter.
Certain
Hearing we cannot because we have
1 minute direction, my lord, for to be mentioned. For direction for paper book. 1 minute it will take.
For paper book?
Yes, my lord.
Please write to be mentioned on top and hand over the slip.
Yes, my lord.
We'll put it as to be mentioned.
File is lying here.
Write to be mentioned on the slip and hand over
Yes,
the slip.
I have written. I have written.
Yes.
If not reach one day, so that should kind of not this week. Some personal ground.
No difficulty. Ms. Shorka, please keep somebody to ask for time when it is taken up. Yes.
Please, your lordship. Lordship, the matter was mentioned on
What is this? Application hearing?
application, my lord.
Hand over.
My
Next.
lord, records cannot be found of one.
Then you approach the register first, find out the records. What can we do? Why
We
do you
have
mention?
tried to find out the.
We cannot do anything. Please take it up with the register.
One order for 10 matter, my lord.
Yes, yes.
And another two mention matter, I mentioned this matter.
We mention for what?
For paper book, my lord. Preparation paper book, my lord.
Hand over.
আমি একটা অর্ডারটা দিয়েছি আপনি দেখবেন তো পাঠিয়ে দেবেন তো
But in this matter,
Yes.
it has come, I now understand for correction. But this matter was dismissed.
We'll just check up once. FA. In the order it was recorded as FA.
But this,
FAT.
yes, this matter was
Immediately correct.
dismissed for default due to my absence. But I was playing subject to lordship's kind sanction if can be restored. But I'm really very sorry that I was not present in spite of giving
So
opportunity.
you have to file an application, 1-page application, file an 1-page application, we'll do that.
Thank you very much.
We always do that.
Good job.
You have to come prepared with the appeal. We'll
Yes,
restore and
yes.
put it on the list then.
Yes.
In the order dated March 18, 2025, FA T number 319 of 2014 was erroneously mentioned in the caption as FA number 319 of 2014. Full stop. Let it be deemed that such correction is effected in the order dated March 18, 2025 accordingly.
Well, I'll give the blessing.
Whenever you file the application, ask your learned junior to mention, we'll take up.
Give the blessing. Give the blessing.
Item number 3, my lord, I have prepared, my lord.
Yes.
My lord, your lordship, my lord.
File it? Yes.
My lord, I'm filing, my lord, just within 5 minutes, my lord.
Acha. Mr. Bera, you are ready with your?
Well, I have given the copy, my lord.
Should he keep it tomorrow then? Under to be mentioned because he has added something.
Added something.
Added something.
My lord, with regard to section 51, with regard to section 51.
No, if you did not argue, how can you add?
No, I argued.
If you argued this,
I
Mr. Bera, you have to look through that also. Whether they have added, if you have to
Regarding-
add anything. If
regarding-
you have to add anything to that, please add that. We'll keep it day after tomorrow, as to be mentioned.
My lord, regarding section 51.
Whatever. Learned counsel for the state submits that certain additions have been incorporated in the additional written notes of arguments, to be filed today, full stop, to give an opportunity to the respondent to deal with the same in the respondent's written notes of arguments, let the matter stand adjourned till March 26, 2025, when it will be listed under the same heading.
That's my submission. Here, giving the list of the cases, not giving the.
Keep it with you, Mr. Bera. If you want to add something, we'll take your written notes together.
I am not, I will not, I will just have.
Yes.
Item number 5.
It has come up at my behest.
Yes, why?
This appeal is regarding a custody matter, my lord.
Right.
The custody of an 11-year-old girl child, my lord. I'm for the mother, my lord.
Yes.
My lord had actually implemented the learned court below's order, wherein visitation rights was given to me every Saturday between 4 to 6 p.m. at a designated place.
Child is with the father.
Child is with the father.
Right.
Father is not there in the station. Father is in Bombay.
All right. Even then, yes.
My lord, be that as it may, for the last 2 Saturdays, no visitation. My lord, what we are apprehensive is maybe the child is in difficulty, she's unwell or something. But
you have to file a formal
we have
application.
we have given notice to the
You have
learned
to file
advocate.
one-page application on that. Otherwise, we cannot pass an order because you have already finally passed an order. You have to file a short application on that they're not honoring the visitation right. We will pass order. Learned counsel for the appellant submits that the respondent is not complying with the visitation order granted earlier by this court. Full stop. The appellant is granted liberty to file an application in that regard and to mention the same for inclusion in the list. Thanks. এটা লিস্টে বাইরে চলে যাবে তখন আবার মেনশন করবে।
Your Lordship,
নেক্সট
Your Lordship. Lordship,
Yes, call on
pardon
next
me
matter,
for,
For the appellant lordship,
yes
the appellants don't want to proceed with the matter further lordship.
you don't want to proceed
Note. Here is may I hand it over?
please. Learned counsel for the appellant, on instruction, submits that the appellants do not want to proceed further with the appeal and the connected applications. Full stop. A written instruction in that regard is filed today and be kept on record. Full stop. Next para. Accordingly, FAT 46 of 2024, along with Can 1 of 2024 and Can 2 of 2024, are dismissed for non-prosecution without any orders to cost. Thank you.
Your Lordship, I am for the appellant, Your Lordship.
Yes, please.
Your Lordship, this matter was placed before the Lavazima court by the SR section because this instant appeal was found defective. And the defect which was found by the Lavazima court was the deficit court fee and the reclassification. The deficit court fee we have already paid, but the reclassification cannot be done because Your Lordship's leave is required. That is why.
We did not put that in our order, reclassification.
Yes, Your Lordship.
Then why is further leave required?
The Lavazima court has not the authority to grant leave. So it has said to mention.
Lazima, oh, acha, acha.
Yes,
No,
Your
no,
Lordship.
we had not granted any leave.
No.
That is what we are asking.
Yes, Your Lordship.
This is against an arbitral award, section 37 appeal.
Yes, Your Lordship. So it needs to be classified as FMAT Arba ward.
Let us check up before passing the order. What is the input order? Learned counsel for the appellant submits that the present appeal has been erroneously classified as an FMAT, whereas since it is an appeal under the Arbitration and Conciliation Act 1996, the same should be classified as FMAT within bracket ARB award, ARB, তারপর award, action, bracket closed. Push up next para. Accordingly, the department is directed to reclassify the appeal accordingly and allot a new number to the appeal at the earliest. Thank you.
Your Lordship, before Your Lordship takes the next matter, may I be
Yes.
permitted to mention Your Lordship for this only for correction in
8 you are appearing.
No, Your Lordship, for my
We have taken up to item 7. You are mentioning a matter now. Don't you know the minimum decorum of the court? Please don't disturb the court like this. You have to learn these things. You are a new entrant to the bar. Please learn these things. One doesn't disturb the court when you are in the midst of taking up matters and item number 8 is going on. Please. Yes. What is 8? Who is appearing in 8? Lozima dekhi ki ache.
Could not be traced out in spite of thorough search.
None appears when the matter is called on. It transpires from a report sent by the City Civil Court at Calcutta that despite best efforts, the records could not be traceable. Next para. The learned Chief Judge, City Civil Court at Calcutta is directed to furnish a detailed report to the learned Registrar, Registrar General of this court as to the circumstances how the records were misplaced in the said court. Full stop. Next para. We expect a full-fledged inquiry into the matter by the learned Chief Judge, City Civil Court at Calcutta. Full stop. The report, comma, along with the inquiry report shall be furnished before this court before the next returnable date. Full stop. The matter be next listed under the same heading on April 21, 2025. Full stop. Let this order be communicated immediately to the learned Chief Judge, City Civil Court at Calcutta for immediate compliance. আচ্ছা, under the same heading বলুন, under the heading to be mentioned করে দিন। Yes. Yes, please. The appeal is against what?
My lord, appeal is against the order of eviction, my lord. Against the eviction of a lady, my lord, who is widow.
Eviction on the ground of?
Eviction on the ground of default and nuisance, my lord.
Default and?
Default and nuisance, my lord.
So if he grants to, we have to direct you to pay occupation charges.
My lord, occupational charges, I am ready and willing to pay, my lord. But here, my lord, the grant stay and occupational charges, my lord. Let it be subject to the outcome of this.
Obviously, yes.
Can one is an application under for condonation of delay?
Condonation of application have not moved. Move it.
Condonation application, my lord, my primary ground is that the
what is the delay?
Delay is 93 days, my lord.
93. What is the ground?
Ground is, my lord, the person is semi-literate, my lord, almost illiterate, and helpless lady, my lord.
He has pleaded 85 days.
85 days, my lord. It is corrected that it is 93 days. As per
But if he has explained the entire period, we don't go by the day. He has to explain till the filing of the appeal. Number of days is immaterial. But your case here is different. Seriously injured, accident, undergo major.
No, that is after January, my lord. Till January, my lord, it is literacy and my lord.
Yes, Mr.
Yes, my lord, this application has to be rejected. Each and every paragraph, my lord, incorrect statement. I could have understood if he had, my lord, come up with clean hands. Kindly comes to page 7.
Yes, page 7.
Yes, page 7, paragraph 13 onwards.
Yes.
Kindly comes to the impugned judgment and decree was passed on 8th October 2024, which was the last working day of the court before it closed for annual vacation. Admitted fact. That learned advocate, that after the learned court opened on 4th November 2024, the defendant petitioner requested her advocate conducting the on her behalf before the learned.
1 minute, Mr. Bhattacharya, give us half a minute. এই এসিটা বন্ধ করে দিতে বলুন, যখন দেখবেন একটু মাথা গরম হয়ে যাচ্ছে কোনো কারণে তখন আবার চালিয়ে দিতে। এখন বন্ধ। Yes, Mr. Bhattacharya, please continue.
To obtain the certified copies of the impugned judgment and other documents so that she can approach an advocate to file present appeal before the honorable court. She was very much aware, and my learned friend says she is illiterate. She knows that a decree has been passed and she has to prefer appeal. Now, my lord, kindly see the next paragraph. That her advocate before the learned trial court went on assuring her that he would apply for certified copy and thereafter hand it over, but the said advocate did not apply for the same till 19 November 2024. Direct allegation against the advocate. Then thereafter such persuasion and request the said advocate had applied for certified copies and thereafter the same was handed over to the defendant on 20th November 2024. Next, Millard, paragraph 17 is very much important. Kindly see. That after the said copy was handed over, the daughter of the defendant petitioner who looks after the case was seriously injured in an accident and she had to undergo a major operation and is at present confined to bed and cannot move without the help of wheelchair. Kindly see, Millard, page 16 says he handed over to Millard the defendant petitioner only on 20th November. Now, Millard, kindly comes to the medical certificate of the daughter, Millard, at page 12. Kindly see left hand side at the top, 3rd January 2025. Millard, before that, Millard, there is a police report also at page 11. Accident occurred on 3rd January. What happened from November to 3rd January? Nothing stated. One. Number 2, kindly, Millard, takes up, Millard, the voluminous stay application which my learned friend has filed. Kindly takes up the pages, my lord, the 325 at volume 2. This is the written statement. Kindly see below page 325. Verification of the written statement. Bhupali Mondol, the Milord defendant herself.
Here also she has herself signed.
Then Milord, therefore the ground that the daughter was all throughout taking steps in the suit, this is not substantiated. Now Milord kindly also comes to Milord page 415 in that bunch. They have filed Milord an application Milord for transfer Milord under section 10 of the City Civil Courts Act. Milord kindly comes to Milord page 417. Kindly see the verification. Therefore, daughter was never taking steps. Bhupali Mondol. And Milord, the allegation is on accident is on 3rd January, November to January. What happened? Milord, completely Milord false statement.
What does your client do? What does your client do?
Client, my lord, doesn't have household duties. My lord,
Household duty means?
Household duties, my lord.
Housewife.
Housewife, my lord, she is widow, my lord. She is widow, lost her husband 32 years back, my lord. And when the daughter was 2 years old, my lord.
She has been signing everywhere.
My lord,
And you are saying that daughter has been looking.
My lord,
she has also signed this application. What prevented her from 20th of November?
My lord, if my lord, it is on that, my lord, it is my idiocy, my lord. I missed, it is, I prefer leave to file a fresh section 5, my lord. If he is on, he is insisting on.
No, you have not mentioned what happened from 20th.
My lord, it is my.
But you cannot withdraw an admission after saying that your daughter was looking after. So you are trying to mislead the court. Your client is.
My lord, it is fact that she she can somehow draw the sign, my lord. She cannot even understand the implication, my lord. So this is the, my lord, this is the
Mr. Bhattacharya,
situation,
she might have signed, but maybe her daughter was looking after the case all the time.
But my lord, it is.
Have you seen her signature?
Definitely.
Have you seen her signature? That will tell you how far she is literate.
See, Milord, page para 14 and 15. Milord, she could understand that an appeal has to be preferred without any legal advice. She doesn't say that the advocate told her to immediately prefer appeal. She had the.
Come on, we are on a section 5. You won't get a walkover here. Signature টা দেখেছেন নিজের বাড়িতে নেই হ্যাঁ হতে পারে 20th February থেকে হ্যাঁ ওই মে দেখি একটা কিছু করে দিচ্ছি একটু কায়দা করতে হবে Can 1 of 2025 is an application for condonation of delay in preferring the appeal. Which of next para? Learned counsel for the respondent points out several discrepancies in the application. First comma, from paragraphs 14 and 15 of the application, it is evident that the appellant was well aware of the necessity to prefer an appeal before this court against the impugned judgment and decree, and comma, as such, cannot be said to be so naive as to not know the legal procedure. Secondly, comma, in paragraph number 16 of the application, it has been stated that certified copies of the judgment and decree impugned herein were handed over to the appellant on November 20, 2024. The explanation for the delay thereafter is entirely based on the accident faced by her daughter and subsequent operation which the daughter had to suffer. The appellant has stated in the application that the said daughter was looking after the case on her behalf throughout. However, comma, upon placing reliance on the pleadings of the appellant in the trial court, comma, which are annexed to the connected stay application, comma, learned counsel for the respondent vociferously contends that the entire impression given to the court is erroneous, comma, since it is the appellant herself who had signed all the documents in the court below, and the picture sought to be portrayed before this court that her daughter was looking after the case is false. Next para, we carefully go through the averments in the application. Next para, a mere glance at the signature of the appellant shows that although she might be barely able to sign her name, comma, she cannot be construed to have proper grasp over even the Bengali language, comma, which is her mother tongue, comma, let alone English. Push up next para. We also find from the records that the pleadings on behalf of the appellant in the court below were primarily in the English language, and the appellant barely signed the said pleadings. Push up next para. Thus, comma, it may not be totally incredible that although the appellant had the pleadings signed by her, comma, the matter was substantially looked after by her daughter. Push up next para. Moreover, comma, since the proceeding arises out of an eviction decree, comma, we do not find any malafidus which can be attributed to the appellant, comma, since delay in that regard would only inure against the appellant. Push up next para. Taking a comprehensive view of the above, comma, we are of the opinion that sufficient lenience can be extended to the appellant, comma, particularly keeping in view the social context that she is coming from a marginalized section of society, comma, is barely literate, and is a widow who is who is already having to survive in life primarily on her own with the help of her daughter. Push up next para. Taking into consideration all the above circumstances, comma, we are of the opinion that the delay in preferring the appeal ought to be condoned. Push up accordingly, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 99 of 2025. Push up, what should be occupation charges?
But,
Now, after those observations will also be considered on the occupation charges. What is the area?
On my lord, last Thursday, my lord had already passed, and my lord, ad interim order of injunction, I appeared a stay.
That was just an ad hoc basis just to protect her from being evicted. Police help was
Today. Now, my lord, I will say, my lord, that there is no prima facie case for grant of a stay.
Why do you say
Now,
that?
my lord kindly takes up the, my lord, impugned judgment.
Default and nuisance.
The default and nuisance.
When did you last see a decree on these two grounds?
No, I
That itself is prime.
get decree on one ground only.
Default.
Default. Better now. No, we were punched up. Yes. Kindly takes up, my lord, the page 330 at, my lord, the second volume. My lord, although these documents the learned trial judge has clearly held were not produced before the learned trial judge at the time of trial, my lord, my learned friend has annexed it, although these should have been brought by way of an application under 41 Rule 27. Now, be that as it may, let us assume, my lord, is seen. Kindly see, my lord, page 330. Now, my lord, kindly see these are according to my learned friend, the learned trial judge, my lord, had not considered these evidences. Kindly see, my lord, area rent for the month of March 2019 to February 21 at the rate of 175. This is, my lord, not compliance of section 71C of the West Bengal Premises Tenancy. It says month by month on 15th day of each succeeding one. And 7.3 says any non-compliance of section 7.1 is defense has to be struck off. One. Kindly next turns over to the next page. Kindly see page 331.
Yes.
Then my lord, kindly see rent of month of March 2019. Again a single month. Then my lord, kindly comes to my lord, page 332. My lord, kindly see rent for the month of April, May, June 2021 at the rate of certain. Again, my lord, non-compliance of 7.1C. Therefore, my lord, defense automatically are struck off. And my lord, kindly see, my lord, next, again, page 333, same thing. Now, my lord, the now lordship had read, my lord, the Chamaria's judgment. My lord, it says section 7 is a, my lord, complete code itself, and it has to be, my lord, a strict view has to be taken. My lord, a series of judgments have come up after this. My lord, after this defense of strike off, my lord, I am entitled to get eviction, my lord, on the ground of default itself.
Very well. Yes, what do you say to that?
My lord, page 329, my lord, is the order under which, my lord, I have deposited.
First of all, the first barrier you have to cross is that these documents were not before the trial court.
This document was 330 was before the trial court.
You say it was before the trial.
330 was before the trial.
331 was not.
331 was not, my lord. 331 was not, my lord. 331 was not, my lord. Thereafter, my lord, it was
Lordship would kind enough to come to page 17 of the impugned decree. Page 17. And you see the first paragraph after issue number 3 at page 17.
Yes.
Discussion and finding.
Hmm.
It is a suit for recovery of khas position, damage and mean profit. The suit, the suit premises situates at premises number 36 by 1A Shorkar Lane, PS Girish Park, Kolkata 7,07,000. As per the location of the suit premises, which is a very lucrative and high-priced area, it is quite natural that the suit has been filed before this court correctly. Stamp duty was paid, duly paid. The suit has been filed by the plaintiff against the defendant as he stopped making payments towards the tenanted premises. The defendant has submitted rent receipt marked as Annexure C, which bears 12 February 2018. Let us check whether this is 12 February.
No. Submitted 3 copies of court challan which are from March 21.
March 20 to 21. 19
March
to
2019 to February
February
2021.
2021. Exactly. These are Millard not
That is what he has annexed.
annexed. Therefore, this is what I am submitting before your lordship. This is non-compliance of section 7(1)(c).
That is different. But you said these were not before the
No,
court below. That is also incorrect.
Others, Millard. The suit did not, Millard, end, Millard, in 2021.
Well, it will be more comprehensive if your lordship come to page 20. The learned court has made it more clear. Well, at exhibit B
20?
series, page 20, internal page 20, running
Yes.
page 447.
Yes.
Exhibit B series, she has clearly paid the rent through court challenge for the month of May, June. She is completely silent as to file it. Exhibit B series are showing that she has paid the rent through court challenge of month of May, June, July and August. It will be August 2024, my lord. So she defaulted for 2021, March 2021 to April 2024. Since, my lord, what happened, my lord? What happened, my lord? This 331 was before the learned trial court. Thereafter, the stopgap, the in between the page which the challans were paid, those were not brought on record, my lord. And but this annotation, this analogy, I am opposing this analogy because this findings shows she is defaulter for March 2021 to April 2024. So, but my lord, here I pause for a moment that before when the challans are deposited before the learned trial court, the process is that unless the preceding month of the challan is shown, it is not passed. So when the finding of the court that if April 2024, if we take it there, that April 2004 is defaulted, then unless then the March 2024, that challenge should have been brought. Otherwise, the challenge should have not been passed. So this analogy is wrong, my lord. I am opposing this analogy, my lord. And my lord, and this on this occasion, my lord, I also could not, and this is again, it is my contribution of my incompetency to her misfortune, my lord. I could not make a petition of application under Order 41, Rule 27. That should have been brought, my lord, but because
So
of
you
the
say that
voluminous-
for the rest of the period also you had paid.
I had paid. I had paid, my lord.
7(2) comply করেছে?
I had paid. I had paid. It is
Very
paid
well,
up to
sir.
April
Bandobast, let us-
2025.
Yes.
Very well. Now, my lord, my learned friend is the conducting advocate in the trial court. My lord, he says, my lord, it has to be also looked into whether 17(2) or 7(2) order, which was disposed on 14 February 2021, whether this was also complied with or not. Because they have not produced the challenge before at the
The
time.
trial
of
court
trial.
has not found that it was not complied with.
That is there.
So
My
that
lord,
is beyond
unless-
the judgment.
That is beyond the judgment.
Then we cannot look into that. It's arguable whether these documents were before.
No, my lord,
if
7(1)(c)
this-
is on the face of the challan, my lord. Let us take it. It
He
was
says that the other documents, other months were paid, but
No, other
irregularly.
But this is that I'm on 7(1)(c). It has to be paid month by month, and the 15th day of each succeeding one, not in for several months at one time.
We have to go through the evidence to look into that. It is arguable. Learned, can 2 of
I will file
2025
opposition stay application, my lord, for determination.
is an application for stay of the impugned judgment and degree and the connected execution case. Which of next para, learned counsel for the appellant submits that the learned trial judge did not take into consideration the deposits made by the appellant from March 2021 to April 2024 and held the appellant to be a defaulter for the said period. Which of next para, learned counsel appearing for the respondent vehemently opposes such contention and submits that the deposits in question were, even if made, sporadic and not in consonance with section 7 within bracket 2 within bracket small c of the West Bengal Premises Tenancy Act 1997, and as such, the benefit and cloak of protection granted by section 7 within bracket 4 of the said act is not available to the appellant. First of that apart, it is submitted that the documents annexed during the period from March 2021 to April 2024, being purported challenge, were not before the learned trial judge. First of that apart, it is contended that due to non-compliance of the order passed under section 7 within bracket 2 of the 1997 act, the present decree, the impugned decree was also justified. Insofar as the last of the above arguments is concerned, we do not find prima facie from the impugned judgment that non-compliance of the provisions of law by non-deposit after the passing of the order under section 7 within bracket 2 are not reflected in the impugned judgment. Insofar as the sporadic deposits being made, we are to look into the facts and appreciate the evidence, as well as to look into the question as to whether the learned trial judge was justified in facts and law in coming to the impugned conclusions before taking a final call on the issue. It would be premature at this stage to conduct a mini trial of the main appeal as such. Next para, since it is an admitted position that some of the challans annexed, copies of which have been annexed to the stay application, were not before the learned trial judge, we grant leave to the appellant to file a proper an appropriate application under Order 41 Rule 27 of the Code of Civil Procedure for bringing such documents on record. However, it is made clear that we are not expressing any opinion on the fate of such application, if filed, and it will be open for being decided at the final hearing of the application stroke appeal as to whether such additional documents can at all be permitted to be brought on record. Next para, be that as it may, since an arguable case has been made out, we grant stay of it is a title execution case number. Ejectment execution case number 7 of 2024, pending in the City Civil Court at Calcutta in connection with the impugned judgment and decree till disposal of the present application. Next para, it is made clear that the question of imposition of occupation charges as a condition for the stay has not been entered into at this stage and is kept open to be urged by the parties at the time of final disposal of the present application. The respondent is directed to file his affidavit in opposition within a fortnight, within a fortnight from date, inter alia disclosing the materials available with the respondent for ascertaining the occupation charges. Reply, if any, shall be filed within a week thereafter. The application shall next be listed on April 21, 2025 for hearing.
My lord, may I mention one matter?
No.
My lord, I was waiting from 10:15. Only I got the connection from the my lord's officer at 10:45. Only one for addition of party.
We cannot help that. We cannot help that. Please mention it tomorrow.
Lordship. I shall be mentioning online.
Yes.
Grateful to you much.
This is an application for restoration of the appeal and the application. Can you look to the...
What about the service?
Service, my lord, it appears, my lord, side report that intimation served. Intimation served.
When was it served? Let us see the affidavit of service. Only one respondent, Mr. Okay?
Yes.
Intimation served is good service. As you can tell. Yes. When was it dismissed for default?
My lord, it was dismissed for default on, my lord, 21st April 2022. My lord, before that, kindly look to the order.
Yes.
My lord, that is what I have annexed.
Yes.
The can 1217 of 2003 not found. Can
Oh.
2261 2000 not found. These are the application, and to make a note that they are already on record. And my lord,
No, these applications were appearing in the list, or the appeal itself was appearing in the list?
yes, but my lord, application were not found, and no accommodation sought for appeal, and the connected application dismissed for default.
This application has been filed within time, Mr. Roki?
Oh yes, yes. Section 5 I have read.
Then not in time. You are saying, oh yes.
No, condonation of delay is there.
Delays of over 2 years. What is the explanation?
Because my lord, you are suffering from chest infection
For 2 years. And there is no section
not
5.
only that. And
You have not asked for condonation of the delay here.
And at the time of
There is only one application.
yes,
You have not asked for any condonation of.
yes, one can look to the application itself on condonation of delay.
Acha, very well. So let us see the explanation, Mr. Roki.
I'll look to paragraph 3.
Yes.
The petitioner one had been suffering from various ailments, namely corona, and at the time of COVID-19, and due to chest infection, as such could not contact the advocate of this honorable court.
This was dismissed in April 2022. There was no corona then.
No, not that only, chest infection, and also the learned advocate of petitioner missed the matter in the list. As such, could not take steps in the mentioned appeal and the connected application.
Where is that prayer? That averment? Missed the matter in the list, yes.
Yes. Paragraph 3.
Despite
Moreover,
Despite service, none appears for the respondent at the time of call. The affidavit of service filed today be kept on record. Full stop. The petition.
Kindly excuse me. This is was being affirmed because since matter has been called on, that's why in course of this day it would be affirmed.
What?
The affidavit of service.
Affidavit of service. Everything is ready.
The affidavit of service filed on record be kept on filed today be kept on record. Kete din. Leave is granted to the learned advocate for the appellant to file the affidavit of service during the course of the day. Full stop. Next para. However, a copy thereof is handed over to this court from which it transpires that notice was it appears that the respondent was intimated but chose not to receive / accept the service. Full stop. As such, we deem the same to be a good service and take up the application for hearing. Full stop. In the application, it has been stated that the appellant number 1, who was conducting the matter, was suffering from the pandemic during the period immediately prior to the relevant date of dismissal of the appeal, that is April 21, 2022. Full stop. Next para. Moreover, the learned advocate for the appellants missed the matter in the list and could not take steps. Full stop. Upon learning of the dismissal for default, steps were taken and the present application has been filed. Full stop. Next para. Since we cannot attribute any malafidis as such to the appellant, as the dismissal of the appeal would not inure to the benefit of the appellants in any manner, we are satisfied that sufficient grounds have been made out for the condonation of the delay and to recall the order of dismissal for default. Full stop. Accordingly, Can 5 of 2024 is allowed, thereby recalling the order dated April 21, 2022 and restoring FA 176 of 1998 along with IA Can 3 of 2003 within bracket old number Can 1217 of 2003 bracket closed along with and as well as IA number CAN 4 of 2007 bracket old number CAN 2261 of 2007 bracket closed to their original file and number on condonation of delay in filing the present application. Full stop, next para. There will be no arrest to cost. Should we direct it to reconstruct the applications? Have you got copies of those applications which are not found on?
Yes, well, because it was in time, and not only that, I do not know.
Have you traced out the applications in the meantime? Have you tried?
I tried, my lord, but I could
Anyway.
not. But copy of the application is.
Are you enjoying any interim order?
There was an injunction sending them the respondent from executing the decree. These are and to go on paying the rent. I have paid all the rents.
We direct these applications to appear in the list and pass necessary directions. The appeal cannot be kept pending for the above applications be listed for hearing on April 1, 2025. যদি না পাওয়া যায় তাহলে application not here বা not found বলেই দিয়ে দেবেন. We will direct you to reconstruct if necessary.
As you wish. Madam, may I file the copy of the application?
We will take up when the matter is appearing in the list.
It should
And
appear.
direct that to be a proper copy. Please just take out 2 extra photocopies of each of the
Yes,
applications. Yes, Mr. Bose, what is the matter?
These appeals arise out of decrees passed in reference cases under Section 18 of the Land Acquisition Act of 1894. Now, there are a series of 8 or 9 appeals. Unfortunately, in all the other appeals, the Section 5 applications were allowed and stay was directed upon deposit. In this, at the time when the Section 5 and the stay was taken up, it was disclosed that one of the respondents was dead. The substitution has been completed, but thereafter, immediately the pandemic had intervened and this had gone out of the list. Now, they are pressing the execution. So I had served the Section 5 and the stay once again on the learned advocate who had entered appearance, but he has communicated to me that he does not have any further instructions anymore, so I should serve it on them. Now, may I say this? The execution is fixed on 12th of April. Kindly keep this on 1st or 2nd of April. In the meantime, I'll serve the parties and the advocates in the port below and come back on 2nd of April.
Both the applications.
Both the applications. Because delay is substantial, but what has happened is we are requiring body. State has contested the land acquisition case.
So therefore you are.
And we are in the dark.
The petitioner shall serve copies of CAN 1 of 2016 within bracket old number CAN 3447 of 2016 and CAN 2 of 2016 bracket old number CAN 5425 of 2016 on the respondents, indicating that that both the applications shall be listed next on April 1, 2025, when an affidavit of service to that effect shall be filed by the appellant. It is made clear that such service shall be effected directly on the respondents and or their learned advocates appearing in the forum court below in view of the submission of learned counsel for the appellant that the learned advocate appearing for the respondents in this court
respondent decree holders matter. State is represented.
Respondent decree holders in this court did not accept service.
No, he accepted service, but he said that he does not have any instruction.
So accepted service, but gave out in writing that he does not have any instruction to appear in the matter. Point this out when we take up the matter next. Even if we can't serve, if the advocate is still appearing, no objection has been taken. Yes. Even if he does not have instruction, we will take up the matter in their absence. Nothing can be done.
Just
for abundant caution, just.
All appeals.
Old appeal, new application, what is the matter?
Order 41 Rule 27.
You have described as Rule 21. So it will be hard along with the appeal.
Yes, my lord. Yes, that can be done.
Use your affidavit in opposition. Affidavit of service filed to be kept on record.
May I request one thing, my lord? Since the 2015 appeal, my lord, the appeal will.
Other directions were there. Paperbooks are ready.
Yes, paperwork filed. Everything is there.
You are for the plaintiff's respondents, all the plaintiff's respondents.
Yes. 1 to 6, my lord.
Very well.
Well, in fact, my lord, nothing remains in this appeal, my lord. It can be, my lord, very short point. My lord,
Let us dispose it off now.
2 minutes, my lord. My lord, we are, my lord, the defendant. Now, my lord, we are facing, my lord, a shoot, my lord, paying for a declaration and injunction.
What declaration? Title?
Title. My lord, declaration, my lord, that was described in the plain, my lord, was from
Sorry, please continue.
was from Pachimuni Dashi. Now, my lord, we have entered appearance and, my lord, disclose the deed that, my lord, that particular person, my lord, my lord, from whom, my lord, they are claiming title, my lord, he has gifted, my lord, entire portion of the land, and, my lord, we have purchased, my lord, we have purchased, my lord, by a sell deed, registered sell deed. That was disclosed.
All gifted to whom?
Gifted to, my lord, one
Your predecessor.
Bilashi Das.
Your predecessor.
Yeah, no, not my predecessor, my lord. One lenient of, my lord, Pachimuni Dasi. She gifted one Bilashi Baladashi. Bilashi Baladashi sold it to us.
That is what we are saying. She gifted to your vendor.
And now, my lord, we have disclosed all the deeds. Now, my lord,
no, those title deeds in favor of Bilashi Bala was before their title deed. They are claiming to the same person.
Same person.
Their title deeds they claim by purchase from Pachi.
By, my lord,
inheritance.
So, my lord,
transfer deeds were not in the court below.
Transfer deeds, my lord, we have disclosed.
Then why did
the suit dismissed?
Why?
To dismiss on the basis of the fact, my lord, we have, my lord, acquired ownership by way of the registered deed of sale. Now, my lord, suit was dismissed on that ground alone. Now, my lord, appeal preferred. In the appeal, my lord, when appeal was pending, my lord, an application order 6 rule 17 was, my lord, filed, disclosing, my lord, a death certificate, which, my lord, signified
preceded your your transfer.
Yes. Now, my lord, that death certificate was challenged. My writ petition, my lord, death certificate was quashed.
This is that for 41.
May I say, my lord, that was caused only on the ground of technicality. That was the ground of, my lord, quashing was, my lord, that prior to issuance of that certificate by the Gram Panchayat, there should have been order by an executive magistrate.
If that was quashed on whatever ground, that was the only premise of your getting this decree.
May I say, my lord?
It has to be decided by the trial court. You can furnish further evidence. Will permit you.
Not that.
We can permit you to furnish further evidence.
What has happened by the impugned order? While order
See, you rely on a death certificate. That is the sole premise of the first appellate court. Remanded.
Yes, while allowing amendment, the court has remanded.
Remanded to be decided on the basis of that
document.
That document.
Yes. Now, in the month of January of this year, from 2016, they kept the appeal pending, my lord, since.
No, but then there cannot be a remand on that document if that document has been quashed.
Lord, may I say, if there will be a document, my lord, since, my lord, my client has already taken, my lord, proceedings.
That's a new document. You have to prove that before the trial court. That will be beyond the remand.
Yes, my lord.
The remand is on the basis of the document which you have already produced. Please understand. Before opening your mouth, please understand what we are saying. We are not saying against you. Remand has been granted to consider a particular death certificate which has been since quashed.
My lord.
If today that remand takes place, it's a quashed death certificate, they'll get a dismissal again. We'll permit you to furnish further documents. We'll modify the impugned order. We'll dispose of the appeal. If both of you agree, we'll dispose of this order for Rule 27 application. We'll take note of that death certificate having been quashed. But we'll modify the impugned order, impugned judgment. We'll say that both parties will be further permitted to furnish evidence on the date of death of this Pachiwala. So you get a new lease of life. Otherwise, even if we dismiss the appeal, tomorrow the remand occurs. The court takes it up on remand. The first thing they'll show is that writ court's judgment, and you won't get a degree in any event. Are we clear to you?
Yes,
so we'll give you a new lease of life. We'll give you an opportunity to adduce evidence on death.
For the appellate court, lower appellate court. Because it was pending with the lower appellate court, but it will again go back, my lord, trial court, again, my lord, appeal, my lord. When, my lord, appeal court, my lord,
their problem, they have prayed for a degree.
No, appeal court, my lord, dismiss the suit.
We won't usurp the jurisdiction.
No.
Because it has already been remanded.
No, remanded on the basis of a document which has been caused by the High Court.
No, the documents which will now be furnished will be new documents. So both of you will lose a forum if we remand it to the appellate court. If they can furnish further documents, you will have to also produce documents or rebut that. That will be a new exercise which was beyond the scope of the trial court. So if the first appellate court is directed to do that for the first time, first appellate court will act as a trial court. So both of you will lose a forum. That is the reason we are modifying the impugned judgment and will dispose of the appeal here and now, right now. And we'll express a hope and trust that the trial court does it within a limited period.
But
What
that be so, my lord,
only one thing, my lord,
the
only-
proceeding, my lord, now which I have filed, my lord, for my lord initiation or my lord issuance of my death certificate, that may take some time, my lord. From 2016, they kept their appeal pending.
No.
Kindly consider this, my
We
lord.
cannot wait for you.
No, my lord. Now, since they have an order from this honorable court in the month of January, now they are trying to, my lord, expedite this. From 2016, they do not had any order, my lord. They never sought to do so, my lord.
So you are actually praying, we can't believe our ears. You are asking us not to direct the trial court
No,
to
I'm not
expedite.
saying so, my lord. I'm not saying so.
Let us dispose of the appeal along with the application right now on consent of both of you.
But
Are you giving consent or not? We cannot force consent on.
I'll give consent, my lord. But my lord, the application which he has filed.
We'll allow this application because he's annexed a certified copy of a writ court's order.
The document, but which he is trying to, my lord, now, my lord, adduce, my lord, as an evidence, my lord.
It's a subsequent event.
But, my lord, that is something, my lord, about which, my lord, no fact has been pleaded in the plea. Lord, it will be totally silent, my
What
lord.
are you saying? A writ petition has been filed, which was subsequently culminated in an order. Setting as you contested there.
The pleadings has to be there, my lord.
What pleadings has to be there? It's a judgment of court, certified copy of a judgment. The judgment contains a narrative. Pleadings have to be there. What pleadings? Order for Rule 27 pleading is sufficient. Did this happen after the decree?
Yes.
Yes.
Then?
Yes. This was not even.
There were no pleadings at all,
My
my
lord,
lord,
death
with regard
certificate
to
was
this.
not even.
We'll consider your prayer and reject
Death
your
certificate was
reject
not
your
even in the pleading in the
objection.
plain.
The appeal and the application are taken up for hearing together on consent of the parties due to the short conspectus of the same. Full stop. The impugned judgment and decree, by virtue of the impugned judgment and decree, sorry, comma, the learned trial judge dismissed a suit for declaration of title and injunction filed by the respondents. Sorry. By virtue of the impugned judgment and decree, কেটে দিন ওটা পুরোটাই কেটে দিন এই সেন্টেন্স the appeal arises out of a suit filed by the respondents for declaration of their title and for consequential reliefs. Full stop. The said suit was based on rights claimed through by inheritance by the plaintiff's respondents through one Pachimoni Dashi. Full stop. Next para. The suit was ultimately dismissed on contest since the defendants stroke appellants were successful in producing title deeds in their favor executed by a person in whose favor the said Pachimoni had gifted the suit property. Full stop. Next para. In the appellate court, comma, the pleadings were amended at the behest of the plaintiff stroke respondents who relied on a death certificate of the said Pachimoni, which apparently showed that Pachimoni had met her demise prior to the execution of the gift deed in favor of the vendor of the appellants. Full stop. Next para. On such ground, comma, by the impugned judgment and order, comma, the appellate court remanded the matter to the trial court for a reconsideration on the basis of such death certificate. Full stop. Para. By way of Can 2 of 2024, comma, an application under Order 41 Rule 27 of the Code of Civil Procedure, comma, the appellants seek to produce the certified copy of a judgment passed by a writ court whereby the very same death certificate on the premise of which the impugned remand order was passed was set aside. Full stop. Next para. It is thus submitted by the appellants that since the very basis of the remand order goes, comma, the same should be set aside. Full stop. Next para. Learned counsel for the respondents opposes the prayer of the appellants and contends that in the absence of any pleadings to the written statement of the appellants in the court below regarding the filing of the writ petition or the attending circumstances leading to the order of the writ court, comma, the same cannot be allowed. full stop. Moreover, comma, it is argued that at this juncture, comma, the appellants cannot have a right to produce the document of the writ court. Full stop. Next para. However, comma, we find that the server copy stroke certified copy of the order of the writ court, of the judgment and order of the writ court dated September 20, 2024, passed in WPA 19079 of 2015, has been sought to be furnished as additional evidence. Full stop. We find therefrom that not only was the judgment passed on contest, but the present appellant, the present respondents were represented therein. Full stop. Next para. Moreover, comma, since the judgment of this of a learned single judge of this court clearly narrates the attending facts, comma, no further amendment to the pleadings are necessary for taking the same on record. Full stop. Although the very premise of the death certificate on basis of which the remand order was passed has now been set aside by a competent writ court, comma, since learned counsel for the respondents takes a plea that the said quashing was on technical grounds and the respondents have already applied for getting a fresh death certificate, comma, we are of the opinion that substantial ends of justice would be subserved in the event the impugned judgment and order is modified to the effect that a further opportunity to be given to the parties to produce documents in support of the contending claims of the parties regarding the date of death of Panchiwala. Full stop. Accordingly, we dispense with formal filing of paper books. Paper books have been filed. Accordingly, comma, Can 2 of 2024 is allowed, comma, thereby taking on record the certified. Have you got the certified copy?
Yes, I have annexed. My lord, the photocopy has been annexed.
No, yeah. Have you got the original certified copy?
Just not today, my lord, but
thereby taking on
yes,
record
yes,
the please file it. Taking on record the original certified copy, comma, which is filed today in court, comma, a copy of which is annexed to the application, comma, on record, full stop, by the said judgment and order dated September 20, 2024, passed by a learned single judge of this court in WPA 19079 of 2015, comma, the death certificate of Machimoni, comma, on the premise of which the remand order was passed, comma, we are of the opinion that the said impugned judgment cannot stand in its present form. Full stop. However, comma, since the respondents have already applied for a new death certificate and keeping in view that the death certificate originally produced by them was quashed on certain procedural grounds, comma, FMA 55 of 2016 is partially allowed on contest, comma, thereby modifying the impugned judgment and order
dated 6th May 2015.
Where is that? We don't find the memo. Memo yes, sir. Impugned judgment and order dated May 6, 2015, passed. Modifying thereby modifying. The judgment, impugned judgment and order dated May 6, 2015, passed by the learned additional district and sessions judge, comma, fast track court 3, comma, Bushirhat, comma, district North 24 Parganas, in title appeal number 52 of 2009, to the effect that the matter be remanded to the trial court for a reconsideration upon giving an opportunity to both parties to lead fresh evidence on the date of death of Pachimoni Dashi alias Pachibala. Full stop. Next para. We make it clear that the death certificate on which the respondents had relied on and which was the initial premise of the impugned judgment and order having been set aside by this court, the trial court shall not take into consideration the said quashed death certificate, but it will be open to the learned trial judge to accommodate fresh evidence, if produced by either of the parties, on to prove the date of death, actual date of death of Pachimoni Dashi alias Pachibala. Full stop. Next para. It is expected that the learned trial judge shall decide the suit afresh on the above, in the light of the above observations, as expeditiously as possible, preferably within 8 months from the date of communication of this judgment and order to the learned trial court. The character 8 months is sufficient.
Only one thing, my lord, trial court will proceed on the basis of server copy, my lord, without insist for certified copy of the judge.
Let the certified copy go. What is the difference? আচ্ছা মেঘনাথ এটা কিন্তু yes, Mr.
Can I appear for the opposite party?
Right.
I appear for the opposite party.
Yes. And two, yes.
Has been filed today, Milord. We haven't used an affidavit to that. They wanted, Milord, and
They are you're the appellant.
No, we are
I'm
the
there. Milord, your also remember this was that property inside Grand Hotel, where I'm saying, Milord, that I'm a tenant, Milord, for a pretty long time, and they are saying license or whatever, Milord. Now the thing is that my ingress and egress was being in jeopardy because Grand Hotel is apparently, Milord, being renovated. Being renovated. So they've shut down my electricity. They've my ingress and egress, everything was in jeopardy. They have filed an application now, Milord, in this appeal, asking for modification of the interim order, which your lordship has already passed. So that needs to be, Milord, dealt with by us by way of an affidavit.
My application, which is Can 2,
and that is
from 2017, the appeal is pending. Now, till date, no paper book, no steps were taken. The appellant is enjoying an interim order that we should not disturb their position. No, my lord, we have not disturbed their position at all. So, for ingress and egress are concerned, we have not disturbed that. Now, there was some temporary disconnection of electricity, which we have restored.
So they want to use an opposition. They have filed an opposition.
Yes, I will use a reply.
File a reply.
I'll use a reply.
The reply also.
No, my lord. This is the
no.
Respect of the supplementary affidavit, which your lordship has granted divided to them on the last
supplementary affidavit
Can 1.
That's the opposition to the supplementary affidavit of Can 1, but not to the main Can.
Very well. File it also.
Main Can file করবি না?
Na main Can file করব। মানে
আমি তো
directions were given to file composite opposition.
Composite opposition.
Is it a composite opposition?
No.
Only to the supplementary.
I'll file a reply to the Can. I have to file a reply to the Can. Can is my Can. Can 2.
Can 2 is your Can. But your learned junior is filing an opposition to the supplementary affidavit filed by them in connection with their Can 1. So you are not using
okay, then a composite reply.
You are not using an opposition to Can 1.
Yes, I will.
File a composite opposition, then take it back.
There is a contempt application pending, Milord, before your lordship, Milord, kindly, Milord.
We'll take up that later. First, let us decide.
Compositely, Milord, together, if it can.
Learned counsel, learned senior counsel appearing for the Appellant stroke opposite party in Can 2 of 2025 files an affidavit in opposition to the said application. Full stop. The time for filing, the respondent is granted leave to file reply, if any, to the same within a week from date. Full stop. Affidavits in opposition filed to Can 1 of which year? Can 1 of 2017. Affidavit in opposition to the supplemented affidavit. Affidavit in opposition to the supplemented affidavit filed in connection with Can 1 of 2017 be also kept on record. Full stop. Since the respondent seeks to file opposition to the main application bearing Can 1 of 2017 as well, comma, time for filing the same is extended for a week from date as well. Full stop. Reply to such opposition, comma, if filed, comma, shall be filed within a week thereafter. Full stop. Next para. Can 1 of 2017 along with Can 2 of 2025 shall be listed together for hearing on April 16, 2025. Along with, what is your
16 and 17.
Acha,
16 and 17 only 2 working days.
on April 21, 2025. What is your
23. 23. If it's
April 23rd April?
23rd.
April 23?
Yes, you're my learner.
April 23, 2025. What is that contempt application?
CPAN number 345 of 2025.
Our order. We have determination now.
You have Lordship has this.
My lord, since your lordship is making the matter determined on 23rd of April, if your lordship kindly extend that time of filing opposition.
It will be too complicated. File it within a week. You had already been granted opportunity of using an opposition to the supplementary. Supplementary contains the main ingredients. Can does not contain anything.
We will file.
You can do it tonight. You can do it tonight.
We will file. We will file.
CPN, give the CPN number. Ask your learned junior to just put it on a slip of paper. CPN such and such, যেটা উনি স্লিপে দেবেন, be listed along with the other 2 applications on the returnability. CPN টা দিলে ওটা ওর সঙ্গে appear.
So grateful to you.
Thank you.
Malad, the CPN be served on us.
No.
No, if you are satisfied only then.
Okay.
Appearing for Grand Hotel from Grand Hotel.
You are appearing from Grand Hotel?
No, from Raja.
Not so grand.
Rajarat Commercial Board.
Yes.
Not so grand.
Yes. Next.
My lord, senior engaged code number 1.
So what? You are there. Move the matter.
My lord, change me. I cannot.
Change it. So what? You are not a change junior.
No, my lord, I'm not ready.
Have you come from somewhere else and joined this chamber? Then you are not a change junior. Move the matter. What about this deceased envelope? Have you taken steps for, you are the appellant?
Yes, I'm for the appellant.
Restoration application has been filed. There are 2 envelopes which show someone has died. Then the application will go out of the list if you are not ready in the matter. No.
Kindly.
An adjournment is sought on behalf of the appellant. Full stop. Very well. As a last chance to the appellant to move the matter, the same is adjourned for the day. You have to come prepared on the next day if he is not there. Only your appearance. And you have to come prepared on the next day. Don't get lost suddenly. Yes.
I'm appearing for the
Yes, Mr.
Opposite party number 1 and 2.
Opposite party?
A respondent.
Right. I mean.
And Mr. Maiti, Mr. Maiti is appearing for the appellant. He requested me to take a 1 week adjournment because there is a direction for remove the mistake.
He has not yet.
He has asked for 1 week time.
Learned counsel appearing for the respondents in his usual fairness submits that it has been intimated by the learned advocate for the appellants that some more time is required to remove the defects in the appeal. Full stop. Appreciating such fairness on the part of learned advocate for the contesting respondents, comma, we adjourn the matter for a week. Full stop. The application shall next be listed on April 8, 2025. 7 will be the combined list day, so 8. Next. Yes.
I am praying for not today, lordship.
Refuse, move. What is the application for?
This matter relates to loss of son of the petitioner lordship died by electrocution.
Oh.
Damage suit was put
This is a
for
section 5 application.
section 5 lordship.
Have you served?
I have no lordship. I have not.
We direct you to serve copy. Why are you asking for
Yes.
time?
Yes, lordship.
Serve copy of electrocution matter. You are the father, the mother.
Father of the petitioner. Father lordship. I have
Father, father.
As regard, my lord, item number 16, I have been instructed to appear on behalf of the State Electricity Board.
So very well, his job gets easier. You serve a copy on Mr. Rai.
Yes.
You appear for all of them because chairman, state electricity ACB, secretary, divisional engineer, and station superintendent. So
Oh, it has been, my lord, West Bengal State Electricity
Yes.
Distribution Company Limited.
yes, now he has to. Will grant you leave to rectify the cause title to the effect. Mr. Rai will guide you. Mr. Rai, please guide him. Because already you have noted your fairness, so you have to guide him otherwise. Just amend the cause title. West Bengal State Electricity Board will be there, now known as, put in the WBSCDCL full form. Leave is granted to the learned advocate for the appellant to rectify the cause title of the application as well as the memorandum of appeal by incorporating the current name of of the West Bengal State Electricity Board, that is West Bengal State Electricity Distribution Company Limited. Company Limited. Full stop. Next para. Such amendments shall be carried out during the course of the day, both to the application and the memo.
Yes.
Both judges' copies. Next para. Since Mr. Sumit Rai, learned advocate, submits that he has instruction to appear, you will appear through somebody, or you will be signed the vakalatnama.
I will.
To appear on behalf of the respondents, a copy of the application as well as the memorandum of appeal shall be served by the learned advocate for the appellant on Mr. Rai during the course of the day. Full stop.
No, lordship. By tomorrow, lordship.
Achha, very well. By tomorrow, full stop. The application shall be listed next on March 20. Achha, very well. April 2, 2025. You'll get 1 week's time. April 2, 2025. Only correction gulo kore neben side. But please serve corrected copies. Correct in your copies also and serve that corrected copy.
My lord,
Yes.
I appear for the respondent led by Mr. Owen Banerjee. My lord, no application copies have not been served upon us.
Did you lodge a caveat?
No, lordship.
Why should it be served?
And lordship, the respondent has already passed away, Anjali Banerjee.
Yes, sir. We have filed an application for substitution. Well, that is scanned 2 of 2.
Since she is appearing, you hand over copies to her
Yes, I
so
can
that
hand.
this is appearing for the first time. This application.
For the first time. But there are 3 applications. One is for stay, another is for substitution, and
All are appearing in today's list.
Yes, yes. All the applications, sir. Section 5.
You have forgotten your full name. Sorry.
Debjani Shengupta.
Shengupta, right. Ms. Debjani Shengupta submits that she has instruction to appear for the respondent, full stop. However, in the same breath, it is pointed out that the respondent has met her demise in the meantime. Full stop. Do you have instruction to appear for the heirs also?
Yes, lordship.
Ms. Shengupta further submits that she also has instruction to appear for the heirs of the deceased respondent, as and when substituted, if at all. Full stop. Next para. Accordingly, the learned advocate for the appellant. What is your name, please?
Priyobrata Botobal.
Accordingly, Mr. Botobal, the learned advocate for the appellant shall serve copies of the applications on Ms. Shengupta during the course of the day. Full stop. Next para. The matter shall be listed. When should you keep it, Ms. Shengupta? Because you have to come prepared.
After 2 days, 3 days, anytime, lordship.
After 2, 3. Very. The applications shall next be listed on April 2, 2025 under the same heading.
I'm deeply
Next.
obliged, my lord. My lord, I'm led by Mr. Owen Banerjee. May I give
Mr.
Owen Banerjee, may I give his
আচ্ছা
name?
যেখানে মিস সেনগুপ্ত বললাম না যেখানে বলেছি ওনার নামটা থাকবে লেড বাই মিস্টার অয়ন ব্যানার্জি
I'm deeply obliged, my lord.
I'm led by Mr. Somitra Bandyopadhyay.
তাহলে বটকবেলের উপর বন্দ্যোপাধ্যায় হয়ে যাবে সেনগুপ্তর উপর ব্যানার্জি হবে বটকবেলের উপর বন্দ্যোপাধ্যায়
Yes, Somitra Bandyopadhyay.
ওটা ব্যানার্জি এটা বন্দ্যোপাধ্যায় লেড বাই বলে নামগুলো যাতে তুই প্লিজ গিভ দ্য নেম
Deeply obliged, my lord.
নেক্সট
Well, I am appearing on behalf of
Yes.
opposite party number 1.
opposite party who is for the petition
I have served the
Your application?
no their application.
You have served what?
But I have some notice. I have intimated the learned advocate by notice. He refused to take because the client did not instructed him to appear.
You mentioned the matter for inclusion. That's right.
I have served. They have received only one.
What application is now pending?
One section 5 application. One
Is a review application.
One review. One
Section 5 in connection with the review.
Yes, my lord. My lord, kindly see the review application. My lord.
What is there in the review? Not as a memo. No memo has been filed. Memo of review.
My lord, I have been served with the
Yes, memo has also been filed. Yes, what do you have to see there?
Well, it is a judgment of affirmation. The coordinate bench of a coordinate division bench affirm the order and coordinate division bench observe that appeal is dismissed. Since
Still, they have a right of
substantial question of the
order for 10 rule 11, dismissed under order for 10 rule 11 at the admission stage.
Yes, my lord.
We'll give them one more chance. Affidavits of service filed by the learned advocate for the respondent be kept on record. Full stop. It appears therefrom that sufficient notice of inclusion of the matter in the list has been given to the appellant. Full stop. However, none appears to move the appellant stroke review applicant at the time of call. Full stop. As a last chance to the review applicant to move the review application and the connected applications, the same is adjourned till April 1, 2025, when the when the matter will be listed under the same heading. Full stop. The learned advocate for the respondents is requested to serve a further notice to the learned advocate for the appellant, intimating the next returnable date and file the receipt on the next returnable date. Don't have to file an affidavit of service, file the receipt.
Lord, advocate is not accepting because the client has not instructed him to appear in this matter.
আচ্ছা তাহলে রিসিট না করে affidavit of service on the next returnable. In the affidavit of service, please mention that we tendered, he refused. Say that, we'll take that.
This is the appeal against a preliminary decree in a partition suit. There is the extent of share is an admitted position. But when the appeal was admitted, my lord, an order was passed that partition commissioner will be appointed, but no
usual
no final decree can be drawn up.
Now, what is your application? Injunction?
I am
appropriate order.
I am for the respondent.
Why this application has been taken out, my lord?
No, what is your application for? That is what
For
you are
vacating the interim order for non-filing paper book. I have served them the paper book
After filing this application.
in October. No. This application has been served, my lord, week ago. I was not aware about this application. I have served them the paper book in October. I have the receipt.
But this is a there is nothing in this appeal.
It is a different question.
There is nothing in this application. Because you have already got copies of the paper
In October.
But may I pray that your lordship will hear out the appeal? It will take 5 minutes time, my lord.
5 minutes have already passed. We could not hear it.
The admitted position. We have all.
What is your ground of challenge?
No, my lord, I am not prepared. I was very much disturbed with this application. My lord, I do not have the paper book, nothing, my lord.
Let it be
How
fixed
this
and
application
hard,
has
my
been
lord. I am suffering, my
Yes,
lord.
it can be, my lord. I cannot stand on the way. But my lord, today, my lord,
We'll keep the application tomorrow.
application.
Come, yes, keep this application tomorrow. Come prepared on what is your ground of the appeal.
Yes,
Lord. My lord, tomorrow, my lord, with the appeal, my lord, hearing.
You have to satisfy us on the ground of the appeal. If there is no solid ground, then we'll pass orders.
Not tomorrow, my lord, then. My lord.
We're not fixing the appeal formally.
Yes, my lord.
You have to show us what is the ground of appeal. If the shares are admitted, then why the appeal?
No, that is not admitted, my lord. I will, my lord, matter was moved, my lord. Thereafter, my lord, I have got this interim order. It was
Achha, we will add the appeal in the next month list.
Yes, your lordship, my lord, it was heard, my lord, by the Honorable Division Bench on July 2022. Thereafter, my lord, this interim order was passed.
Which division bench? They are still available?
No. That division bench is not available.
Can 3 of 2024 is an application for appropriate orders. Full stop. Learned counsel for the respondent stroke appellant submits that despite the direction of this court, comma, no paper books were filed in time for which the interim order granted earlier be vacated. Full stop. Next para, learned counsel for the appellant points out that prior to getting a copy of this application, comma, paper books were already served on the respondents. Full stop. Next para, hence, comma, although there was a delay in preparation of the paper books, comma, since those have been filed, comma, the present application has been rendered infructuous. Full stop. Accordingly, Can 3 of 2024 is dismissed on contest as infructuous. Full stop. Let the appeal itself, any other application is pending.
No.
Let the appeal itself be listed for hearing in the monthly list of May, not April. Monthly list of May 2025.
Deeply obliged. Deeply obliged.
April not possible. Hmm.
No, I am the respondent, petitioner, appellant, sorry.
You are appearing on different sides.
No. Both side I was, let me complete the sentence. Last occasion, my junior submitted.
Yes.
I am praying, Lord, you kindly allow him to continue.
Very good.
So that I can take my seat.
Yes. Absolutely, Mr. Panja, please take your seat. No difficulty. We'll hear, Mr. Yes.
My lord, the last order, your lordship allow me to file the formal memorandum of appeal.
What was this in connection with? Just remind us, please.
This is a collection of the land acquisition matter under section 18. Reference was made that was enhanced the amount. It was
So you have to deposit the amount as a condition of stay.
Yes, my lord. That difficulties in the last order on 11th March 2025. Your lordship directed me to file the formal memorandum of appeal.
No memorandum of appeal was filed.
No, because that writ petition, we have challenged that order through writ petition that has been converted appeal. That's why your lordship
Yes, you have to file a formal memo, otherwise not been filed.
The difficulties is that the certified copy, your lordship, that it has not been original certified copy was not annexed with the writ petition. It was the Xerox copy was annexed with the writ petition. That's why we approached before the court below for certified copy. Now, yesterday we came to know from the learned advocate of the court below that the record has been sent to
This
Calcutta High Court because state has also filed an appeal. Therefore, my lord, we could not obtain the certified copy from the court below.
We'll dispense with the filing of certified copy. We'll direct you to file a memo with a photocopy.
Yes.
And we'll direct the original impugned judgment in the record as a to be sufficient.
With the original judgment
Must be in the record.
State appeal with the state appeal, my lord. That's why if both the appeal be hard analogous.
State appeal.
Yes, state has also filed the appeal. And
but they are not here today. How can we?
Yes, therefore, my lord, if your lordship direct me to serve a copy upon the state, they will also, because one judgment 29 appeal LA case has been decided by common judgment, and all 29 appeal was filed by the state.
Well, let us give you first the liberty to file memorandum of appeal, and you have state functionaries are there. The special land acquisition officer and all of them are here.
Yes.
You must have served them.
Yes.
Did you direct you to serve on them? Just check up, please, whether they have received.
We have. Yes, we have served upon the state, my lord.
No, these respondents have to be individually served because they have been made as parties, not as state.
We have, my lord, served upon that.
All the respondents have been served.
No, all the respondents.
Was there a direction? Copy of this, we had directed you to serve on all the respondents by your order dated March 11, 2020.
Yes.
So complete service and come back. We'll give you that liberty to file the memorandum today. Please check up whether service has been effected on all the respondents. Most importantly, the land user.
Yes, it has been not been served, my lord. It is returned for insufficient address. But the address we have obtained from that order of the trial court, that which I have, my lord, certified copy of the application. They have
their application for enhancement gave that address.
That address, and they have, my lord, execution application. They have filed that address.
Very well, Mr. I will take that affidavit of service. and regarding the other respondents, you have not served.
As regard, my lord, other respondent in REIT application, we have not served.
No, in this stay application.
Stay application.
You have to serve copies of the
Yes.
stay application. If service is not complete, we can wait for a day. We can wait for some time.
Yes, my lord, we shall check.
Very
next
well. Since it transpires that service has not yet been completed on all the respondents in respect of the stay application, let the stay application be adjourned till April 9, 2025. Push up next para on the said date, on the returnable date, a proper affidavit of service shall be filed by the appellants. Push up next para. By our order dated March 11, 2025, we had directed the appellants to file a formal memorandum of appeal since a writ petition was converted by order of court into the present appeal. However, it is submitted that the certified copy of the impugned judgment has been annexed with the memorandum of an appeal preferred by the state against the self-same impugned judgment. It is further submitted that in connection with the said appeal, the trial court records have already arrived before this court, which makes it difficult stroke impossible to obtain a certified copy of the said impugned judgment and decree. Next para, in any event, since the records of the trial court have already appeared, have already been sent to this court in connection with a different appeal, the purpose of justice would be subserved if both the appeals, which arise out of the self-same judgment and award, are heard together. Accordingly, filing of certified copy along with the memorandum of the present appeal is dispensed with. The appellants shall now file a formal memorandum of FAT 93 of 2023 along with a photocopy of the impugned judgment and award, which shall be treated to be a proper filing of the said memorandum of appeal for the present purpose. Next para, such memorandum shall be filed within a week from date. Next para. This much. Let the application appear on the next date. On the next date, we'll dispose of the application if they don't appear. We'll direct both the appeals to appear together and we can take a.
My client is apprehending
that
the
unless the memo is filed, we cannot pass any order. We have kept it on 9th of April.
That is the problem.
No, Mr. Paja, you just communicate that this order has been passed and it is pending before the court. We can't pass any order of stay at this point of time.
Let them not ask us to deposit the entire money.
We cannot pass any order at this point of time because execution case will take some time.
It is the
it cannot be executed in a day.
If there is a word desire, it is sufficient. If there is
no, Mr. Paja, before a memorandum of appeal is filed, at least we will not take up.
Well, may I take the point then?
We'll pass an order of stay, full-fledged order of stay on the next date and direct you to deposit the amount on 9th.
If your lordship so pleases.
My lord, I am for the appellant petitioner, my lord.
Yes.
My lord, this is affidavit of service, my lord. Service has been effected, my lord.
Section 5 first.
Yes, ma'am.
What is the delay?
My lord, delay of 55 days, my lord.
Reason?
My lord, reason, my lord, the appellant was not aware that dismissal of the counterclaim, my lord, they have to apply for the appeal, my lord, before this honorable court.
Oh, you have already filed an. Acha, no.
Partition suit, my lord.
Your partition suit.
No, my lord, we are the defendants, my lord.
Acha.
We filed, my lord, counterclaim. Partition suit was allowed, my lord.
Counterclaim for?
Counterclaim, my lord, for declaration that one deed, my lord, is not binding upon us, my lord. And in respect of, my lord, two schedule, my lord, X and Y, my lord, the partition has to be done, my lord. That was, my lord, turned down. And against that, my lord, we have filed this appeal, my lord. And since, my lord, the appellants were not aware, my lord, for that reason, my lord, it is, my lord, the delay was caused for.
Oh, there is already an appeal on the part of the.
No, my lord, their partition suit was allowed, my lord. My counterclaim, my lord.
You are not aware of what?
My lord, that we can challenge that part, my lord, that counterclaim part, my lord.
Ignorance of law is not a good.
My lord, that is the ground that has been
Not
taken in the application, my lord. I cannot.
We could have understood if there was they had also filed an appeal. And you thought that one appeal would suffice, you could cross objection.
However, my lord, it is I cannot improve, my lord.
But here you'll have to be penalized for telling the truth.
My lord, this is the ground.
But it has been well settled by the Supreme Court. Ignorance of law is not a ground.
My lord, that is the.
Where is your reason?
My lord, it is. My lord will find paragraph number, my lord, 5 and 6, my lord. In paragraph number 6, my lord, it has been stated that the petitioners have no knowledge of challenging the judgment and decree so far it relates to rejection of the counterclaim filed by the petitioner. Therefore, my lord, there is some delay. There is no other.
Sorry, reason is not sufficient.
I understood, my lord. Even
reason is not sufficient. There is no question of condemnation. Span of delay is not important, but and you know English, you conduct business, so you are worldly aware otherwise. This is not a ground.
My lord, may I pray for one thing, my lord? May I file one supplementary affidavit to this application, my lord, to avoid that cost part, my lord? Because delay, my lord, is for 55 days, my lord.
Yes, but it has been settled by various judgments. Span of delay is not important. Not only that, there is no ground at all. We are not also convinced on apart from ignorance of law not being a good ground. What is this? Then everybody would say this. Petitioners have no knowledge of challenging the judgment and decree so far it relates to rejection of counter. You are agreed by the counterclaim rejection only.
My lord,
we could have understood this. That's why we are repeatedly asking you. Sometimes what happens? One appeal is filed, and you are secure in the belief that in that I can take out a cross objection. That we can understand. Here they have not. They have won.
My lord, if I can improve, my lord, because at this stage, my lord, by this pleading, my lord, I cannot improve anything, my lord, more. So
Learned counsel for the appellant at the inception submits that certain other grounds of condonation of delay have been omitted from the application under Section 5 of the Limitation Act due to bona fide inadvertence. Accordingly, on the prayer of the appellant, leave is granted to the appellants to file a supplementary affidavit to Can 1 of 2023. Such supplementary affidavit shall be filed by the next returnable date, that is on the next returnable date, that is on April 9, 2025. A copy of the supplementary affidavit shall also be served on the respondents in the meantime. The affidavit of service filed today be kept on record. Since it appears therefrom that a copy of the applications have already been served on the respondents, no further copies of the applications need be served.
My lord, injunction application has not been served. My lord, I have
application.
My lord, only one application, injunction application.
Sorry, there is some other defect.
Yes.
Name of defendant number 6A and 6E has not been incorporated.
Name of 6A and 6.
My lord, for 6A, my lord, one application that is Can 3 of 2023 has been filed, my lord. 6E, my lord, they are here, my lord. Kartik Mitro, Pratima Dash, and Mamoni Roy. My lord, they are.
Let's find out who is 6E.
6E, my lord. I have a copy of the plaint, my lord.
6E is Anima Saha in the decree.
Anima Saha, my lord. Yes.
Anima Saha is a party here in the memo.
Anima Saha has been made defendant pro forma respondent here, my lord. My lord, you will find after plaintiff's respondents 1 to 3, she has been made as defendant pro forma respondent, my lord.
Anima Mitro?
Anima Saha ni Mitro, my lord. In application, in any application, my lord, you will find that anyway.
No. Anima Saha is 4.
4, my lord.
Ani Mitro ache.
Yes, my lord. In appeal, she has been described as
And you have filed an application for what?
For, my lord, recording the death of
other years record. যেটা বললাম তার সঙ্গে অ্যাড হয়ে যাবে the office report indicates that the names of defendant number 6 small a within bracket and 6 small e within bracket have not been implemented in the appeal push up insofar as defendant number 6 within bracket small a comma learned counsel for the appellant submits that an application has already been filed for recording his death comma since his heirs are already on record push up next para. Insofar as defendant number 6 small e is concerned, comma, she has been implemented as pro forma respondent number 4 in the memorandum of appeal. Push up next para. As such, comma, the defects pointed out in the memorandum of appeal in that regard be deemed to stand cured. What about deficit code fee you have to put in? 100.
100. My lord, I pray
for however, comma, the appellants shall put in the deficit code fee of rupees 100 within a week from date. Put in 100 within a week? Have a copy of the supplementary
application can be disposed of, my lord. I am not in.
What can?
Can 3 of 2023.
What is that?
Recording of death of my lord.
You have served a copy of that?
Yes, my lord. That's served. I have not served the injunction application, my lord.
Can 3 of 2023 has been filed for recording the death of the defendant number 6 within bracket small a in the code below who has been arrayed as appellant number 9. Push up next para. It is pleaded in the application and submitted by learned counsel for the appellants that the heirs of the said appellant are already on record. Push up. Your paragraph number 4 is blank in our copy also.
My lord, that FAT number has not been mentioned.
Next para.
I mean, tended apology.
Since none appears to oppose the application despite service, comma, can 3 of 2023 is allowed, comma, thereby recording the factum of demise of appellant number 9, Sukumar Mitra, push up the learned advocate for the appellants shall carry out the necessary correction to the cause titles of the memorandum of appeal as well as the connected pending applications to that effect during the course of the day.
My lord, only learned advocate
by tomorrow.
On record by tomorrow.
The course of the data tomorrow, by tomorrow.
Instead of mentioning my lord, appellant number 9, my lord, he has not been made appellant, my lord. Before
that is a cause title.
My lord, in the cause title that is that in prayer it is, my lord, kindly refer him as defendant number 6A, my lord. Otherwise, there
appellant number 9 যেখানে যেখানে ইউজ করেছি কেটে দাও defendant number 6 এটা যেটা বলেছি
before filing this appeal, my lord, it's fine.
You have mentioned in the cause title of the application full of errors. Thank you.
Number 22.
My lord, I am for the petitioner.
Yes.
I am for the plaintiff appellant petitioner, my lord. My lord, this is application for my lord expedite the hearing of the appeal.
Appeal is against?
Appeal is against, my lord, dismissal of my partition suit on the ground of non-joinder of necessary parties.
The instant application bearing can 2 of 2024 is an application for expeditious hearing of the appeal. Full stop. Next para. Upon hearing, you have served a copy on the other side.
My lord, it was served, my lord, earlier. My lord, I don't find anything.
In view of the innocuous nature of the prayer, comma, we dispense with service of copy of this application on the respondents. Full stop. the appellant is directed to put in requisites for the service of notice of the appeal on the respondents within a week from date, full stop. The trial court records be called for by special messenger at the cost of the appellant, comma, also to be deposited within a week from date, stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who sub liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Extremely clear. Thank you. ডিফেক্ট আছে কিনা দেখতে হবে। ভালো করেছে, সুবিধা হয়। হ্যাঁ, খুব সুবিধা।
23, I beg to appeal for the respondent 245, defendant number 245.
What about service on the others?
Service was not yet complete as the petitioner could not find.
Can't hear you. Use the mic.
The petitioner could not provide us with the address of the respondent, so service was not complete, Your Lordship.
You have not given addresses of the respondents in the cause title?
Yes. Lordship, those address we could not find. The petitioner could not find the respondents in those address. The petitioner
Are you enjoying any interim order?
Yes.
Yes, Your Lordship.
No, then you will vacate the interim order, then you will find the addresses.
May I submit one thing?
No, wait. It's a partition suit.
Yes, partition suit has been refused.
Dismissed.
Yes.
Injunction, what is the difficulty in injunction?
What the problem the appellant will also face, what I gather, because my lord, initially we didn't appear in the suit. It's a suit for partition, completely suppression of facts. They have suppressed the share of 2 daughters. Subsequently, my lord, predecessor of those, my lord, respondents, they are
dismissed on those grounds.
Dismissed on primarily what I found 2 grounds. One is that they did not produce any document so far as the predecessor is concerned, from where the trees start. And second point is that they have denied the share of the defendant. That is why the learned court below holds that moment you denied the defendant
How
share.
can there be a partition?
Yes, that is the exact reason. My lord, first part, the learned court below records. The plaintiff, however, has not filed any documents to show as to how Tripura Chakraborty is the, my lord, court acquired the right title and interest over the suit property. But my lord, in their injunction application, my lord, I have found that they have annexed the LR records of the Tripura Chakraborty. They could have very well exhibit that document.
At least prima facie something.
Prima facie something. Because my lord, their claim is that they purchased the property from one co-sharer. According to that purchase, my lord, they asked for partition. Now, my lord, the deeds are also, my lord, based on fraud. Because, my lord, initially...
No, but if you did not take those points in the court below, how can you...
Lord, that is my difficulty. So, I can pray before your lordship, if your lordship pleases, can send back the...
Let all the parties be served.
My lord, then appellant will also be, my lord...
You are directed to serve copies by previous orders. Where is your affidavit of service to that effect?
Kindly take, my lord, order dated 3rd March.
Yes, we are taking that up only. Where is that affidavit of service? You are directed to file affidavit of service.
Your Lordship, we were instructed by the petitioner that the address they couldn't, the petitioner provided us with.
We'll vacate the interim order then.
Your Lordship, may kindly grant us.
Is it a joke before the court? You implicate some persons with certain addresses. Now then you have practiced a fraud upon the court. How could you get those addresses? Now you are saying your client has said he cannot find the right address. Then you have filed it in the wrong address.
This is the instruction given to us, Your Lordship. This was filed.
We'll vacate the interim order right now.
The addresses is also matching with the plane. Because
so why are you saying wrong address and all these things? Where is your affidavit of service?
It is instructed to us by the petitioner.
You were directed, forget your instruction. You are before a court of law. You are not bound by illegal instructions of your clients. Court directed you to serve copies. Where is that affidavit of service? You directed to file an affidavit of service today. Where is that? If you serve, it comes back, then we can understand. That means you have not served at all. Where is the service? Unless you serve, because you have served at the address which was given in the court below. Unless you serve, how do you know that those are wrong addresses? And if your client says those were wrong addresses from the inception, then you have suppressed the right addresses. We'll vacate the interim order. At the time of call, learned counsel appearing for the appellant submits that the appellant / petitioner instructed learned counsel that the addresses of some of the respondents given in the cause title of the memorandum and the application are erroneous. Full stop. However, learned counsel appearing for respondent numbers
2, 4, 5.
2, 4, and 5 submits that the addresses as given in the cause title here tally with the cause title in the code below. Full stop. Next para.
Plain. Copy of
Acha, tally with the addresses given in the plaint. Full stop. But you are the plaintiff.
Yes.
Full stop. We do not find anything on record to indicate that any attempt was even made to serve copies of the application for injunction on the absentee respondents as per our direction dated March 3, 2025, nor is any affidavit of service filed today by the appellant. Full stop. Next para. Hence, we have to proceed on the premise that either service was not even sought to be effected on the absentee respondents, or that knowing fully well that the addresses of the said respondents were erroneous, the appeal and the application was filed disclosing such addresses. Full stop. Moreover, since the appellant has not complied with the direction to serve copies and file any affidavit of service today, nor is the learned advocate for the appellant able to explain the reason for having not filed an affidavit of service today, apart from that the appellant has instructed him that erroneous instruction was given regarding the addresses of the absentee respondents, we are of the opinion that for violation of the direction of the court to serve copies of the application on all the respondents, the ad interim order of status quo granted on March 3, 2025 ought to be vacated. Full stop. Accordingly, we vacate the status quo injunction. Accordingly, we vacate the ad interim order of injunction dated March 3, 2025. Full stop. Next para. The appellant is directed to effect service immediately on the absentee respondents, indicating that the application shall be listed next on April 21, 2025 for hearing, and file an affidavit of service to that effect. Full stop. In view of appearance of the respondent numbers 2, 3, and 4, 2, 4, and 5, 2, 4, and 5, service on the said respondents is dispensed with.
Can I pray one thing, Your Lordship? My Lord, kindly direct the appeal be tagged with that, because end of the day, if it is goes back, my
No,
Lord.
no. Not at this stage.
Great.
এসে বলছি যে ভুল অ্যাড্রেস দিয়েছি ননসেন্স হ্যাঁ ও সার্ভ করেনি সেটাকে চাপার চেষ্টা করছে সার্ভই করেনি এরা নিজে থেকে দেখে অ্যাপিয়ার করেছে অথবা এদের সঙ্গে কলিউশন ইয়েস হোয়াট ইজ দ্যাট
Well, this is a affidavit of service.
ইয়েস
Isn't it good? 378 of 2024.
ডিপার্টমেন্ট থেকে ট্যাগ করে দিয়েছে বলছে আছে
My lord, I have been wrongly, my lord, 26 my match, my lord.
আপনার দেখা হয়নি ঠিক করে
আপনার দেখা হয়নি।
So this is 24. You are in 24. Affidavit of service ফেরত দিন
Beg to appear on behalf of the respondent, Your Lord.
এইগুলো এরই কাগজ তো Yes, Alimony.
Lord, we have.
Oh, this is that matter where you said that we
Yes,
disbelieved but
yes,
found out that
yes,
you were
Your
correct.
Lordship. The very same matter, Your Lordship.
Right.
Lord, our reply, my lord, needs to be filed.
Really? They have given copies to.
Yes, Your Lordship. The copies have been.
Yes.
No, I'm not going to take much of your lordship's time, my lord. I've drawn
Mr.
up.
Chatterjee, what is the background? This was a divorce suit by them.
Yes, by us.
Oh, that failed and you have come up. Right.
But the husband lives in America, my lord. He has a sizable income, it seems, my lord, from
Just because he resides in America and he is now jeopardized. He may come back any day. So you should take that into account also.
So he's probably, my lord, a citizen, if I'm not mistaken. I am no green card holder or something. He's not coming back in the near future. If he comes back, good for me, my lord. There's no problem at all. But now, my lord, what the situation is, kindly takes up my reply. I have tabulated, my lord, the income And these are from admitted, my lord.
Those
incomes.
affidavits of assets.
Yes.
Which paragraph?
Kindly takes up, my lord, page 5.
Yes.
There is a tabulation. my lord.
Right, right. There's the child of this marriage.
My lord,
you want 60,000 per month.
I get it, my lord, from the other proceeding.
Alimony?
Yes. My lord, he earns 13 lakhs 55,660 per month, which is
You have calculated 1/3 very clearly.
I have done. I have done that.
Why not 1/5?
Well, there is no real, my lord, law on that. It's basically, my lord, your lordships have, my lord, age-old one single
Nothing.
bench
There is no
decision.
law.
There is no law on that. It's about the just like the
Considering that
welfare
you
of the
have,
child.
sir, strategy right, you are right. Rule of thumb only. 1/3 to 1/5, that is a rule of thumb. But again, there are several judgments which deny that.
None.
But here you are already, if you had no income, then you would go on their higher side, 1/3. But 60,000 you are, that is also maintenance. You're as per your affidavit, you are unemployed.
I can't say I'm unemployed. I was employed at one point of time, but now, my lord, there is nothing.
You are employed as?
My lord, I have, my name was used in one of the, my lord, interior designer firms.
Owned by them?
Not owned by anybody, my lord, but not by me, not by anybody known to me. I used to at times give a freelance, my lord, but your lordship knows anybody who knows a little bit of interior designing. There is a firm, I go and do a freelance. I have shown that, my lord, before your lordship sees my ITR of 20.
You are not there till now,
No,
as on dates.
By nothing.
So when were you terminated or stopped going there? What
Lord, it was a freelancing thing. So there was not a, my lord,
is still there then?
Not there. My lord, it's not an
What was your
income.
earning from that
Yes,
freelance?
that's why I've done my ITR.
Your affidavit of asset, should you look into that?
Yes, yes. এটা কোথায় গেল ITR টা? হ্যাঁ। My lord, that your lordship will আমাদেরটা কোথায়?
No.
Yes.
Wife
Kindly
affidavit of
turns to,
asset.
my lord, my affidavit of assets. Takes up my affidavit of asset.
Yes.
Kindly takes up page 29. This is my bank account.
Yes.
And I made a mistake by saying, my lord, my ITR. I don't have an ITR. Page 29, my lord, your lordship will find. They have said that these are certain incomes which have come in from somewhere, 5,874, things like that, my lord, software. Kindly have a look at that, there is
What is
nothing.
this, 26th of August 2022? TRF Abhishek Fogla HUF.
That's the maintenance.
No.
That is the money given to me from the HUF which my brother has given to me as a gift. My brother.
Your
That
maiden
also
name
they are
was,
saying is an income.
Maiden name was Fogla.
Fogla. 26th August, your lordship is on, my lord.
Yes.
Yes, that's Abhishek Fogla, my lord. That's my brother. 9 lakhs and all.
Rest big amounts are apparently maintenance.
None of them are maintenance from anywhere, my lord. It's
No, maintenance by him.
Yes. Yes. Big amounts your lordship will not find anywhere else.
10th of September is him and also.
Yes, so even if your lordship takes up, my lord, a very
strict view of your.
Yes, my lord. There is nothing which on record shows, my lord, that I earn something.
This is the disclosed income, 13,55,000.
This is a disclosed income. Disclosed.
Net or?
No, my lord, in America, I don't know how do they do, but it's the disclosed
Yes,
income. He earns this. That's what he has said. I'm not even getting into what I have said.
So this should be the total amount paid to you?
Absolutely.
That 60,000 will go into this?
Deducted.
Yes, what do you say? Why not this?
No, my lord, I'll keep it very crisp, my lord. Let us come to the very fact that the affidavit of assets and liabilities which has been so filed, my learned senior has stated, the very fact that ABN Designs, which is the interior wherein apparently she was giving services, is not in play. My lord, I can show documents to the effect of January 24, if my lord just permits me.
Are they part of your objection or anything?
Your lordship, they are part of my objection. However, there is a document which we have found very recently, which is not a part of
What does it
my
show?
particular opposition.
Don't give it to us. Just tell us.
Now, Lordship, this is a Facebook post from Godrej Locks. Now, Lordship, what has happened there is that there is a Jeeves 2025 award. Now, your Lordship is very well aware that there are several award ceremonies which take place for interior designer architects who
We are not at all aware. You have make us aware.
Your Lordship, so your
Interior
Lordship,
designing, we have no idea.
Godrej Locks had presented a Jeeves 2025 ceremony wherein they had invited certain architects who are working, and they had given them awards for their work according to the architectural designs and the work which they do. Your Lordship, it is very clearly written that Abhishek Fogla and Neha Bajoria of ABN Design Studios. Your Lordship, this is
her brothers or something.
no, Your Lordship, Abhishek Abhilasha Fogla. That is what is written, my lord. Abhilasha Fogla and Neha Bajoria of ABN Design Studios. And this is a post wherein she receives the award on 14th of February 2024, my lord. 2025, my lord. I stand corrected. So, my lord, that the very first limb of submission is, my lord, that they have suppressed certain facts. Now, my lord is very well aware of the fact that suppression of fact takes into consideration as to why should adverse inference not be brought. Now, my lord, from their affidavit
You got that after affirming these affidavits?
After affirming. Because, your lordship, we had affirmed it on 28th of... Yes, your lordship.
File a one-page affidavit, put that on oath, give a copy to them, we'll take it up next week. Mr. Chatterjee, you...
Lord, kindly have a look at it. 28th.
This document which is...
Yes, kindly have a look at it.
No, this document is
Godrej
yours.
Locks has said something about that he's named me and another person of ABN such and such. And how, may I ask this question to myself? How does that
Godrej
become
Locks
relevant?
is quite, I mean...
Is a company, who probably, deals with interiors. So he has asked ABN, me to represent ABN or something like that. I don't even know about this probably. I'll take instructions, that's no problem.
They are very thrilled to introduce you as the
they are very
finalist.
thrilled, yes.
Finally, as finalists.
ABN.
Introduce the finalists of the GV's award, Abhilasha Fogla and Neha Bajoria of ABN, not
Yes,
for.
Yes.
So you work there, you and Neha Bajoria,
No, they
and
wouldn't
you are the
even-
persons who have been, you are the finalists.
No, I can take instruction, but it
Take
doesn't show, that I am getting money out of that.
Also, my lord,
You are doing interior architecture, interior decoration for charity. For Godrej Locks.
This is good. Godrej Locks, has said.
Godrej Locks gives you an award out of nothing for a charitable person who does.
Has he given me an award?
Who does this interior decoration for slums?
Hasn't given me an award.
You are finalists there.
Finalists.
You must have done some work to give.
ABN is the finalist, They ABN, because they think I am representing ABN, that's why I'm there.
ছবি না শুধু এখানে বলা হয়েছে যে to introduce the finalists Abhilasha and they have been named by the names. I mean, no, you belong to ABN Design.
That's what they say.
It is off design platform.
That's what they say.
That is what Milord I can prove. That is what Milord I can prove, even if Milord does not take into
Why
consideration
shouldn't
this
an adverse
particular
inference be
document.
drawn if they bring it on record?
Even
you have
if
to
they-
explain this.
I'll explain it. There is no problem at all. The problem is, whether I'm earning out of that. They will, if any company will not pay me in cash. Very, very certain on that. Because it has to go, into
We're
the
not
account.
certain on that.
No. Company, cannot pay me in cash.
We don't know what this is, ABN Design Studio.
That's
What is it?
exactly what I'm
Whether
trying to
it's a
tell you,
company, whether it's a partnership, whether it's a person, sole proprietorship, we don't know.
They also don't know.
No, obviously they don't know. It's your special knowledge. It's your special knowledge.
I'll explain it.
Give us the details regarding ABN Design Studio then, in your opposition.
Whatever vis-a-vis me, whatever is there,
Yes,
with respect
whatever
to
is
ABN,
there.
I will disclose that.
We want to know the background.
We'll do
give you some more time to use an affidavit.
Well, 1 week is enough for me, I'll be in the meantime, I'll do.
They will do that in 1 week. 1-1-2. At the time of
Milord, kindly, before taking just this document into consideration, Milord, this document is just a small part of what I wanted to show. However, your lordship,
you wanted to show what else?
Your lordship, that the wife was earning and was also drawing salary. Your Lordship kindly takes up the affidavit of assets and liabilities filed by the wife, my lord.
Yes.
And kindly takes up page 29 at first.
কোনটা দেখাচ্ছ?
Page
29, yes,
30
29.
of, Your Lordship, I stand corrected, page 30 of the affidavit of
30,
assets and
yes.
liabilities. Lordship kindly sees there is an entry dated 29th November 2022. Has Your Lordship got it?
Yes, also before that 31st of October.
Yes, Your Lordship, there is 31st of October, and I have in-depthly pleaded that they have mentioned, Your Lordship, that these are as salary. 18,648. Thereafter, Your Lordship, there is again a salary 29/11/2022. Your Lordship, interestingly, after this page, the very same summary, the salary has not been mentioned, but this very same summary goes on. And I have
29/11?
So 29/11 2022 at page 30, 29/11/2022 and 31st/10/2022.
Salary is 12,000.
Yes, 4th of February 23 also. This
Correct. Also, Your Lordship, 19/9/2022 at page 30. 19/9/2022. That has also been drawn as salary.
Yes.
দিয়েছি তো সেটা। আরেকটা কোথায় গেল?
Your Lordship, these are admitted salaries from the statement. Now, Your Lordship kindly takes up paragraph A4 of the affidavit of assets and liability which has been filed by the wife.
Paragraph
A4.
A4, right.
Now, Lordship kindly sees that it is written that I am residing separately alone in a rented flat. The detail of the rented flat is given. Now, Lordship kindly matches it with the affirmation which has been made on the top. She says that she is a homemaker residing at flat number 7E, Tower 3B, Active Acres, 54/10 DC Deroy Road, Kolkata 15. However, she deposes that she is living separately in a rented flat. No rent receipts have been annexed. Though the affidavit of asset liability does not warrant the rent receipts, but this is a fact which we had taken that this is a house of which she is herself stating that she is paying 40,000 rupees as rent for this particular premise.
What does she say that?
She states in her affidavit of asset and liability as rent. Kindly takes up page 5, Your Lordship. She has given a categorical bifurcation of why does she need an amount of rupees 3 lakhs. At the very top, Your Lordship, she has written rent to the tune of rupees 40,000. 40,000 per month. Your Lordship, I have specific averments that in the entire statements of accounts, the rent has not been mentioned. The only rent which Your Lordship will find an entry for rent, Your Lordship will find an entry of rent only at page 54 of the affidavit of assets and liability. Kindly takes up page 54 of the affidavit of assets and liability which has been filed by the wife. Has Your Lordship got it?
Wait. Page 54, yes, please.
Your Lordship kindly sees the entry dated 31/1/25. The very last entry at page 54.
Yes.
Your Lordship, it is stated as rent, withdrawal amount 89,000. Your Lordship, even this 89,000 does not match with the 40,000, and this is the sole entry of rent in the whole entire account statements. Your Lordship, also in the rejoinder which has been filed by the wife,
Rejoinder filed today. This affidavit in reply or some other rejoinder is there?
No, the affidavit of reply which has been filed by the wife.
Yes.
Your Lordship, there are two things which, Your Lordship, the first thing is that there are huge sums of money which we have stated that these monies are her income. One of which is what your Lordship had pointed out, that is 9,05,000 rupees coming from Abhishek Fogla HUF. She states that to be a gift for her, this thing. Your Lordship kindly takes up page 13 of the affidavit in reply.
Yes.
Paragraph 26, fifth line after the full stop, Your Lordship. It is denied. This is a denial with regards to paragraph 11C of my opposition. Your Lordship, it is denied that I hold insurance and pay premiums to that effect. I state that I am a member. Now she has admitted, we have stated that she is a member of a group which is called BNI.
What is BNI?
Now, Lordship, BNI is a group which takes, which is a pool of business people who come together for the purpose of expansion of business. You need to pay a particular sum of money to become a member of this particular group, and thereafter they help you in expansion of business. Your Lordship, she has specifically stated, I state that I am a member of BNI without any paid subscription fee for the purpose of expansion of any business. I state that the money received from Abhishek Fogla HUF is a gift from my brother Abhishek Fogla. Anita Fogla is my mother, and the amount indicated in the table with respect to the said paragraphs is also a gift from my mother. Now, Lordship, this is where I haul upon my submission. Your Lordship kindly takes up paragraph 11C of my affidavit in opposition and kindly tallies it with the bank account statements of those particular dates.
হাজবেন্ডের অপোজিশনটা কোথায়? অ্যাফিডেভিট অফ অ্যাসেটস এন্ড লায়াবিলিটিস রয়েছে হাজবেন্ডে দু ভলিউম রিপ্লাই এটা written objection. This written objection, this is yours.
Written objection.
Yes. Which paragraph 11C?
They have denied it at paragraph 11C, Your Lordship. Kindly takes up the dates and kindly
Give us the page number of 11C.
Page number 33, Your Lordship.
Yes.
Your Lordship kindly tallies it with the dates. Even if the submission of the wife is to be taken without any suppression, this 9,05,000 rupees, Your Lordship will see, is a credit entry in the bank account statement of the wife. Now, a credit entry means that amounts has been received. Fine enough. Now, Lordship kindly sees entries dated 5/7/23 and entries dated 11/11/23 to the tune of rupees 15 lakhs and rupees 7 lakhs.
So apparently she is a member of the HUF and this is
that is my categorical averment that this 9,05,000 rupees is first of all not a gift. They are claiming it to be a gift. I am claiming that this is not a gift. This is what they have suppressed. This is the income from Abhishek Fogla HUF wherein Abhilasha Rajgadia is a member or is working for gain, which she has suppressed. First thing is that, Your Lordship. Second thing that they have mentioned that I am passing my present days on the mercy of my family members, stating my paragraph 11C entries to be entries as gifts. Now, Lordship is very well aware that a gift needs to be a credit entry in the bank account statement of the wife. These are, Lordship, 15 lakhs, 7 lakhs. These are debit entries. Now, what does the respondent wife want to say? That I am gifting 15 lakh rupees and 7 lakh rupees to my mother and then saying that I cannot earn anything?
Debit entries.
These are debit entries. These are entries which have been credited to the bank account of the mother. 15 lakh rupees and 7 lakh rupees are debit entries in the account statement. How can a gift be a debit entry is what I question myself, your lordships.
5723. Analysis.
Obviously, the debit entries could not be gifts to them.
Absolutely.
So that's an error.
No.
Now, even if you go by that, now 9,05,000 is the only amount which we see she has received from the HU from her bank statement.
Correct. Your
Now, a one-time payment, how can you relate that to her income from the HU?
I shall.
Why can't that be a gift? I mean,
that is the reason, your lordship, that I am saying that this is what I have stated. This is what I have reasons.
15 and 7 are obviously debit entries, cannot be gift.
No, that is what they have stated, that this is a gift, even if it is taken on face value.
No, the learned advocate on record forgot between left and right. Well, doing it. That is an error, obvious error. Debit entries could not be gifts by them.
No, it was
to them.
Your lordship also kindly sees the categorical denial which they have.
But at the end of the day, regarding from that HUF, you are right. 9,05,000 is that sum is there.
That sum
but
is,
it's a sole entry one
that
time.
is a sole entry, your lordship.
So therefore, it cannot be a regular income from the HUF. We cannot derive that
Absolutely. I'm not deriving that. I'm just saying that this is a huge sum of money which has come from a HUF. Now,
Yes.
if my brother has to gift it to me, the question so arises, why from a business account? That is
HUF
subject
is
to
Hindu undivided family. Might not be an HUF. Might
absolutely. I bow down to your
Might not be a business account.
Your lordship, BNI India Enterprises Limited.
BNI.
That is, he has paid subscription to that effect. Wide an entry dated 9/5/24, and she's denying that she has not paid any amounts. Also, she holds a general insurance, which is wide entry dated.
Where have you stated that 9/5? Whatever you say.
Page 33. Page 33. The entry.
Oh yes,
the entry is tally, your lordship. The entry is tally.
This is a real debit entry.
Yes, your lordship. This is a debit entry which has gone to BNI Enterprise, and this is the sum of money which needs to be submitted. She also holds the general insurance which she has denied.
Business Network
International, BNI. Your lordship.
Party books. Over the period of income হয়ে গেল কত বছর ধরে চলছে দেখাতে পারে ইউএফ থেকে আমাকে পয়সা দিচ্ছে ইউএফের ব্যবসা
Yes.
Your lordship kindly takes up page 31 of my affidavit in opposition.
Yes.
Your lordship, admittedly, the wife has stated that she is a homemaker. But however, her bank account statement states otherwise. Your lordship, at page 31, paragraph B, I have categorically stated the dates, the person to whom these payments has been advanced, and the amounts which have been advanced. Majority of which are corporates. Your lordship, this is my categorical averment that she is not a homemaker, but she is an entrepreneur and she is a businesswoman. I have shown
These
that
are investments.
Your lordship, these are not investments. These are
are
payments. These are your lordship.
We don't know divine sparks. She might regularly buy something from these things.
Your
How do we know?
These are payments.
I'm surprised he hasn't pointed out, Milord, that there are payments made to Shopper Stop, to Zomato.
Halwazia and Razorpay and
Razorpay is something that you pay.
What is Halwazia? Has to something with halwa must be.
No, Lordship, just because the name is Halvasia does not mean that it
Does
needs
not
to be
necessarily
from.
mean. Bharat Motor Company, I mean, Divine Spark, we don't know. She may have regular 2000, 1000. These may be corporates, but all the sweet shops are also nowadays. Some of them are
these are
corporate.
payments made to Swiggy. If your lordship has blood, knows blood.
That's that much we also.
So if that is a payment made to a corporate, I mean, it's really becoming.
Corporate, the word is
If I make a payment to Shoppers Stop,
1,534, 1,000, 2,000.
Lordship, these might look like small payments, your Lordship. Now, what I want to apprise your Lordships of the fact is that she's an interior designer, your Lordship. For
It cannot make her an entrepreneur. I mean,
your Lordship, let me, your Lordship, for the purpose of interior designing works, your Lordship, certain raw materials are required. For that, your Lordship, certain small amounts of monies are paid regularly.
yes, some are paints, hardware, and all these.
Yes, your Lordship. That
will require a lot of conjecture, probably.
Paint hardware, I can't paint my house.
Chatterjee, your commentaries in the meantime create more suspicion.
Your Lordship, also.
You're not confident.
Your Lordship, the kindly comes to page number 88 of my affidavit.
2,000 rupee payment, 1,700 maybe or may not be. That is in the realm of conjecture. We cannot say Salt Lake Service and this Lake Auto Services. These are not entrepreneurial payments. Sorry.
Your Lordship, the reason to put in those
BNI, yes, maybe, but she's trying to make something of her career, maybe. But mere membership in BNI does not mean that she.
I shall prove that. I shall satisfy to all the speculations that your Lordships have. Your Lordship, kindly takes
my lord doesn't have a speculation.
I stand corrected.
Whatever. Yes.
Your Lordship, kindly takes up page number 88 of page 88 of my affidavit in opposition.
Yes.
Lordship, before going into this particular order, I shall explain to your Lordships the backdrop. Now, Lordship, what had happened is that the wife had filed a domestic violence case. The wife prayed for an interim maintenance. She was awarded an interim maintenance to the tune of rupees 35,000. She was not very happy with that. She went on to prefer an appeal, wherein the quantum of maintenance was enhanced to 60,000. Now, Lordship, kindly sees at page 88, the date of the order is 27/3/23. So this order was passed on 27/3/23. Now, Lordship, kindly comes to page 92.
Yes, 92.
Now, Lordship, before that, kindly comes to page 90 first.
Yes.
Lordship, in all fairness, I should submit that I, being the husband, had not filed my affidavits of assets and liabilities till date. In the lower court proceedings, while this order was passed, which has been recorded. Kindly sees paragraph 2, line number 4. The respondents did not submit any affidavits of asset and liabilities. Kindly marks it, your Lordship. This is important. Why? Your Lordship, kindly comes to the next paragraph, starting from being aggrieved. Appellant is entitled to get monthly interim maintenance to the tune of rupees 1 lakh. So this was the prayer made in the domestic violence, this thing, that the maintenance that I want is to the tune of rupees 1 lakh only. She had prayed for 1 lakh rupees. She got 35,000 rupees. She went on appeal, and the appellate court took note of the consideration and has arithmetically evaluated that the arithmetical calculation of the lower trial court was wrong, and as per the basis of the arithmetical calculation, the wife is entitled to maintenance to the tune of rupees 60,000.
At that point of time, you had not produced your affidavit of assets, so she was not aware of your income.
Now, your Lordship, this order has not been challenged. They sat tight on this particular
that is not
order.
binding before a civil court. Definitely not.
Also,
125 is or domestic violence is not. These operate in separate spheres. Those are adjusted with each other. Yes.
Also,
and you did not file an affidavit of she was not aware of your income. It has to be
Absolutely.
commensurate with your income also.
Absolutely.
Yes.
Absolutely. Now, Lordship, admittedly, at this particular point of time, as on March 25, I am paying 1,20,000 rupees, including arrear as maintenance. Post March 25, Your Lordship, I will be bound to pay 60,000 rupees as per the appellate court's order. Now, Lordship, 2-3 things which I have made categorically very clear is that, first of all, there is suppression of material facts in the affidavit of assets and liabilities. Now, Lordship, kindly takes up page 130 of my affidavit of opposition.
Yes.
Now, Lordship, this is a copy and a printout of the LinkedIn profile of the wife herself. Now, Lordship, kindly takes up page 131. Now, Lordship, from January 2020 till present, which is 3 years, 8 months, she is working as an interior designer at ABN Designs. Now, Lordship, prior to that, she was working as an architect at Raj Agarwal and Associates. Prior to that, she was also working as an architect at ABN Tower and Transmission Private Limited from March 17 to January 2020.
What is her academic qualification? Have you got any idea? Has she?
Yes, Your Lordship. She has mentioned that she is a bachelor's in architecture from Manipal University.
Yes.
Now, Lordship, kindly takes up page 133. We will be very clear on who is the owner and founder of ABN Design Studios. Now, Lordship, this is her own Facebook post, wherein on 25th January 2020, she states that she has started a new job at ABN Design Studios. And after, Your Lordship's 25th January 2020, there is a hyphen wherein it is mentioned owner and founder.
Page 133.
Page 133, Annexure K.
Yes.
Your Lordship sees started a new job at ABN Design.
What is this? This is from what?
This is her own Facebook post. This is her own Facebook post. Started a new job at ABN Design Studios, wherein she mentions that she is an owner and founder of ABN Designs. I shall not trouble Your Lordships.
I hope you have not congratulated. One of the congratulations. Her brother has.
Now, Your Lordship can keep turning the pages. I shall not disturb Your Lordships to the pressure of turning the voluminous pages of my affidavit in opposition, which goes on to show that this ABN Design Studios has given advertisements at various Facebook portals for necessary expansion of business. Now, she is the owner. She has whole and sole right to expand her business and work accordingly. Now, Lordship kindly takes up page 165. I shall be very, very crisp with what I want to show before Your Lordships.
Yes.
Now, Lordships, page 165, Annexure L, Your Lordships will find BNI Legends, Kolkata, North, West Bengal, India. This is where she is a member. And Your Lordships can see that she has done a lot of joint venture meets. She has done feature presentations. At page number 167, Your Lordship will see that she is also receiving an award for the credible work of architecture which she has been doing. She has also been rewarded to that effect. She is not just an architecture person, Your Lordship. She is a good architectural person and she has got humongous knowledge and she is earning and working from gain for that. And also that because of the fact that she is doing such great work is that different invitees are inviting her because now she has become a celebrity architect, Your Lordship. Marriage.
BNI Legends seems to be an advertising platform of sorts.
Your Lordship, BNI
What
in
they say
itself,
will maybe inflated also. I mean, they give gifts to the rewards to their own people, and they
Yes.
started with 10 people and all these things.
Yes, yes, yes.
What is BNI Legends? It's not so legendary as we suppose.
No, Your Lordship, what is BNI? BNI is a pool of people who had started to
They
help
advertise
businesses.
themselves, pat their own backs and
Yes,
advertise,
yes, yes.
advertise
Yes.
themselves.
And it is pan India that they help businesses to
Everything
expand.
is pan India. Our pan shop also says nowadays I'm pan India.
Now what they have done is that because they need to take people from different, so there is BNI not 24 Parganas, there is BNI
But
South.
it's very clear from all of this that at least she's working as an architect for quite some time and
Yes.
has been associated and earns from that at least.
Correct.
That presumption is created, and you ask us to draw an adverse inference because she has suppressed income from that.
Your Lordship, three things. Adverse inference is definitely there, Your Lordship. Now, there are just three things I have been able to prove or satisfy this particular court about three facts, Your Lordship. First fact, that the wife is not uneducated, she is educated. And that she is not only educated, she has put her education into good use. And she is earning, was earning, and she has got capacity to earn as well. That is my first limb of submission.
And this was a Hindu marriage.
Special marriage.
Yes.
Your Lordship, the second limb of my submission is that I have been able to prove to this court by the very documents of the wife that she is the owner and founder of ABN Designs.
What was that page again? Yes, page 133.
Page 133, which is her own Facebook post when read with her own LinkedIn profile. Now, Lordship, if at all she is the owner and founder of ABN Designs, then ABN Designs can either be a partnership or can be a company or can be a proprietorship, Your Lordship. I cannot be aware of that particular fact. But that fact of business has not been mentioned in the affidavit of assets and liabilities. So the whole business income of the wife has been suppressed in the affidavits of assets and liabilities. There can be a whole another bank account of the wife, which she has to prove. And business income ought to be there.
How can I prove the negative?
ITR return, she is saying that I am earning less than rupees 2.5 lakhs. So I am not entitled to file any ITR. And on the other hand, she is paying 15 lakhs and 7 lakhs to her mother. How is she not filing returns? She is definitely filing returns. Her income from the statements show that she is falling under the criterion of an IT return applicant. She ought to file the IT returns, which she has suppressed. She has also suppressed about the fact that she's a homemaker. No, she's not a homemaker. She's a working woman, very much educated, has filed this application because she thinks that claiming alimony shall be a bounty for the husband. Your Lordship, my fourth limb of submission. Your Lordship, these were the big submissions which I had. Now, Your Lordship, let's come to the smaller submissions which I have, which Your Lordship might take into consideration, might not take into consideration. Your Lordship kindly sees the application of alimony which has been filed.
Yes.
Your Lordship, nowhere in the four corners of the entire application, though it is mentioned that this is an application for alimony pendentalites, there is no mention that under which provision do they want this alimony.
Not true.
Also, Your Lordship, that is the reason I was
small point.
That is the reason, Your Lordship. I was telling that
dilute your bigger submissions.
Now, Your Lordship, kindly the last submission by which I end is, Your Lordship, I had taken this preliminary argument on the maintainability of this particular application. Your Lordship, before that, they have specifically admitted and have taken and have spelled it out in their rejoined in their affidavit in reply that the verification of the affidavits of assets and liabilities is wrong. Now, Lordship, this particular verification was done when the Indian Penal Code was in its existence. Your Lordship, this application has been filed while BNS is in existence. So the verification and the
how is the BNS relevant? You are meaning Evidence Act and BSA?
No, not Your Lordship. No, Your Lordship. The affidavit, the verification in the affidavit of the assets and liabilities, Your Lordship, we need to verify it that if at all there is any declaration which is false or incorrect, then I will be penalized under such and such sections of the Indian Penal Code. Your Lordship, because this application has been filed at a stage wherein the Indian Penal Code is not in existence. Now, these particular provisions need to be replaced not by the Indian Penal Code, but by the...
Where do we find that? Which page of their affidavit of assets?
Yes, Your Lordship, page 21, wherein they have declared in accordance with the Indian Penal Code.
Right.
And Your Lordship, they have...
You have to read the current provisions into this.
Right. And Your Lordship, they have categorically stated that yes, they shall make necessary changes at page 10 of their affidavit in reply. They have categorically stated that though they have followed Rajneesh versus Neha, but if leave and liberty is given, they shall incorporate it according to the Bharatiya Nyaya Sanhita. Your Lordship, at the very instance, how has this application been filed? Your Lordship, there was a divorce proceedings. Divorce was not granted. They had failed for cruelty. Now, for the very first time, they have come up with this alimony application. I understand that Your Lordship had denied my preliminary submission that this is a continuation of proceedings. As because this is a continuation of proceedings, this application is allowable. But Your Lordship, the statute does not bar an independent application for
what did
alimony
we
pending.
say? That this is an independent application.
Your Lordship, an independent application not before the appellate court for the very first time, but before the trial court, because the provisions under section 36 do not
What
bar...
do you intend to say? We don't understand.
Your Lordship,
You say this is not an original application, or it is an original application?
No, Your Lordship, this is an application. This is an independent application which has been filed. What I am trying to appease this court of the fact is that section 36, now because this application was not filed in the trial court.
No alimony application was filed in the trial court?
No, never.
Achha.
No application for alimony was filed in the trial court. This has been filed for the very first time at the appellate court.
Throughout the suit, there was no...
Throughout the suit, there was no alimony application. They sat tight after the 60,000 rupees order because apparently...
That was...
Correct. Now, Lordship, they had... This was...
that you can argue that till filing of this appeal, they have not sought for enhancement.
No.
That you can definitely argue.
No. So, Your Lordship, this is the very maintainability.
So they were content with section 6 rupees 60,000. That you can argue.
Yes. Your Lordship, this alimony application at the very face of it is this appeal is essentially an appeal as against a divorce decree simpliciter. No appeal, no alimony was preferred in the trial court.
Her divorce suit was dismissed.
Her divorce suit was dismissed, Your Lordship. But no alimony application was preferred. No alimony was even sought for. And also the grounds for filing this application, Your Lordship. What are the grounds which they have made? Just one ground which they have made.
When? Tomorrow? Today we have that.
Lordship can keep it as...
We'll keep it in the list and take it
as
up
Your
tomorrow.
Lordship so please.
We'll continue tomorrow.
Oblige, Your Lordship.
Some of the applications have been disposed of before this, so we'll continue tomorrow.
Oblige, Your Lordship.
The application for alimony bearing can 1 of 2024 is heard in part for further hearing tomorrow.
Before rising, Your Lordship.
Yes, Ms. Sharkar.
45 is not this way. 45.
Who is your other side?
Everything has been lodged. Order 41, admission stage. Because if not count...
45. 45 to not this week.
One Indian is
45, not this. 45.
With regard to item number 29, other side is Math.
I have got the instruction over telephone. My lord, kindly take it up day after tomorrow.
Item?
29.
29, not today and not tomorrow. Right.
Item number 41, my lord.
We'll take up 41 tomorrow. The other matters will be taken up tomorrow because today we have these farewell things.
But
If anybody is in
Deeply
difficulty,
obliged, my lord, deeply
ask your
obliged.
learned friends to ask for time. We'll consider that.
As your lordship please.
Yes, sir.